Well, hello everyone, and welcome to Uncivil Law. I hope everyone is doing with me now, or is having a great day. With me today is Alita from Legal Bites. Say hello, Alita. Alita's frozen. Alita has completely frozen, and Nate's
Oh
camera is not working. You broke Alita, Nate.
no,
You broke Alita.
it's that's a hell of a way to freeze too. It's like boom, like she's about to speak. She's dropped out too. We've lost her.
Well, this is going just about as well as could be expected.
Hey, we're
Great.
here, man. We're here. We're here.
This is going well. So, anyways, for tonight's stream, Alita will be back in a second, and Nate won't be joining us on camera. So it might be me and my two phantom friends in my head.
What?
Which is
Hey, I am
different
here.
different than normal.
Just because you can't
Are
see
you though?
me doesn't mean
Are you
I'm
though?
like the,
Oh, he's
the
backstage.
voice.
There he is. Yeah, there she is. She's
Oh, there you
Hey,
go.
sorry. Didn't mean to ghost everyone there for a second.
Oh, very unloved.
Oh, no.
Well, today's stream we are doing a Supreme Court oral react. This sometimes I do on my stream. I do it by myself. But, this is our regular Wednesday meeting, and it's on my channel. So my channel, my rules. Guess what we're doing today? We're doing an oral reaction to the U.S. Supreme Court because we can. We're doing the case of Mahoney School District versus BL. And here is a brief summary of the case. BL, who was at the time a student at the Mahoney area school, tried out and failed to make her high school varsity cheerleading team, making only instead the junior varsity team. Dun, dun, dun. Over a weekend and away from school. This is important because she's not at school at the time, geographically or temporally. So that's actually an important detail. Over the weekend and away from school. She posted a picture of herself on Snapchat with the caption, "Fuck school, fuck softball, fuck cheer, fuck everything."
That's not good for the algorithm, baby.
Yeah.
I was thinking the same thing.
We're quoting it verbatim, man. This is the news. The photo was visible to about 250 people, many of whom were students at the school, and some of whom were cheerleaders, who presumably did not approve it as their next new cheer. Several students who saw the caption photo approached the coach and expressed concern the snap was inappropriate. I'm sure. The coaches decided that BL's snap violated team and school rules, which BL had acknowledged before joining the team, and she was suspended from the junior varsity team for the year. She sues the school under 42 U.S.C. 1983, alleging her suspension from the team violates the First Amendment. The school and team rules were overbroad and relate to viewpoint discrimination, that those rules were also unconstitutionally vague. The district court granted judgment in BL's favor, ruling that the school had violated the First Amendment rights, and the Third Circuit concurs. Thus, the question presented, does the First Amendment prohibit public school officials from regulating off-campus student speech? And the dominant case that is on point that you will hear about in this discussion is a case called Tinker, which we've also covered on my channel, Tinker versus Des Moines. Vietnam era, some students wear a black armband to protest the Vietnam War. The long and short of it is students do not forfeit their rights at the schoolhouse gates, and schools cannot prohibit speech that is not going to be unduly disruptive. But of course, the internet changes everything. Or does it? So today we're going to hear oral argument from the school, from the U.S. government, and from BL about what the new standard should be for our wonderful First Amendment. Any initial comments, Alita, before we get into this thing?
Yeah, I did want to say that there is one other wrinkle in jurisprudence here is that a case called Frazier, where the court didn't actually use that particular analysis about disruptive behavior. So that's I think going to be the other tension point in this case, where in Frazier they had a student that made a speech again on campus, but he made a speech on campus that was I guess a little bit lewd, so the school decided that was the type of behavior that a school could regulate, which again, like I said, was on campus. But I think although they didn't explicitly state that it was that it was behavior that would be disruptive to the students, to school, or whatever, I think that's probably something that sort of falls into that category nonetheless.
Yeah, very much so.
Yeah.
And there's also a case which I don't know if it'll be cited because I can never remember the name of the case. I always remember as the Bong Hits for Jesus case. But yeah, there was a kid who held up a sign at a school event. The sign said "Bong Hits for Jesus." I think it was during like some sort of school track and track and field event or something.
Yeah, that was
held it. Yeah, that was it Alaska or something weird? I think it was Alaska.
It was Morse v. Frederick.
Okay, yeah, I can remember the name of the case.
I don't have that memorized. I literally was just researching the jurisprudence to refresh a little bit. So I can maybe look a little impressive.
You can just pretend you have a committed domestic memory. I can't believe you don't remember that one.
How can you guys forget bongs for Jesus? That's like the best First Amendment case ever, right?
That's pretty good.
I remember the actual the phrase. I just couldn't necessarily remember the name of the case off the top of my head. But
so the long and short of that decision was the school could punish it principally because it was occurring during an official school event.
Mm-hmm. So the court even has a compelling interest even to try to steer kids away from drugs, et cetera, et cetera.
Yeah, illegal activity. But I will say this really is going to come down to, it seems to be jurisdiction, right? Because that's essentially what this is, a jurisdictional question. Where does the school's jurisdiction end? Does it end when your child is in the custody of the adults? Was it end, after school eras? And to what type of contract can these schools have with these minors, right? Because they're saying there's a code of conduct, and she signed this code of conduct, right? And the parents agreed to this code of conduct. So a lot of your rights you can waive, right? You can waive some of your rights. So is that a waivature of right? Again, I don't think these arguments are convincing. They weren't convincing to the Third Circuit, nor were they convincing to this.
I don't think waiver is going to be a principal part of this decision. I don't see that happening.
But this was the argument of the school board. Right? They were arguing that the code of conduct, no? So, I don't know where this goes, but we can talk about each one of those principles.
Unconstitutional conditions, my friend, unconstitutional conditions.
But you can waive your constitution. You can waive constitutional rights. Yeah, you can waive the right to an attorney, for instance. You can Sometimes. But can you waive your right to free speech?
All right, we're going to find out. So let's listen to this. Now, I don't have the official. Okay, here's the additional technical rub. Since OYA does not have the aligned copy of the transcript with the audio, I have taken the audio and run it through a AI tool, which produces the audio automatically so that we can see and listen to it at the same time. So it won't be perfect in terms of the transcript, but close enough because it's all we got to work with.
But how long is it?
It's an hour and a half because there's 3 people talking.
Damn. All right, let's do it.
Plus commentary.
Woof.
We will hear argument first this morning in case 2255, Mahanoy Area School District versus BL. Ms. Blatt?
Thank you, Mr. Chief Justice, and may it please the court. Tinker should apply off campus for 3 reasons.
What?
I hate may it please the court. I remember having to say that. I was like, why do we say this stupidity? May it please the court.
It's tradition.
I think it's literally written in the brass plate, I think, on the Supreme Court lectern.
Yeah, but they say it everywhere.
Just so you remember at least that much words, in case you get up there and you completely freeze. You can look down and you can read what the first sentence is supposed to be.
May it please the court. Okay, I'm here.
First, such speech can cause on-campus disruption. Second, respondents' approach would create chaos. And third, a school nexus requirement and Tinker's substantial disruption test guard against abuse. First, off-campus speech, particularly on social media, can be disruptive. The internet's ubiquity, instantaneous and mass dissemination, and potential permanence make the speaker's location irrelevant, yet the decision below arbitrarily treats location as dispositive. Second, respondents concede schools can address off-campus speech, but they propose an administrative nightmare where the sheer complexity heightens the risk of calamitous error. First, a 7-part test would define the school environment. Second, then one would check if the off-campus speech fits within 5 separate First Amendment doctrines that have never been defined in the school context. Tinker would mystifyingly toggle in and out of coverage as kids move about the day. This court should not substitute the 20-year status quo of applying Tinker off campus. Third, schools cannot target political and religious speech. Tinker applies off campus only when the student targets both a school audience and a school topic. And more broadly, this court can clarify Tinker's reach both on and off campus. It is irrelevant that critical or unpopular speech is the but-for cause of substantial disruption. The speech itself must be culpable. It must inherently compromise school functions, like organizing walkouts. or the speech must objectively interfere with the rights of others, like severe bullying.
One wonders how, given that particular test, this speech falls into that category. How did it inherently compromise school functions like a walkout or interfere with the rights of others like bullying? One wonders, but yeah.
But before you start this, this is fucking amazing. This person is like nailing it. Like she's got me thinking. Like I disagree with this side, but oh my God, she's really making me think. I think
I really
do argue in front of the Supreme Court.
I really do like the rule change that was 2 terms or 3 terms ago.
2 minutes
where
straight talk.
where they're going to guarantee you that first 2 minutes without interruption. I really like that rule change. It's like we're gonna guarantee you for 2 minutes, and we're not going to interrupt you, so that you can make sure to get that perfect 2 minutes out. It's like the best. It's like the best moot court nightmare. Come out with a perfect 2 minutes. You know?
But she's nailing it though. She is nailing these 2 minutes in the chat. If type of 1 if you think she's nailing this 2 minutes, because she is nailing it. Even though I think she's wrong, she's nailing it.
Yeah, we can respect it even if we disagree with it.
Right.
But if listeners riot because they find speech offensive, schools should punish the rioters, not the speaker. In other words, the hecklers don't get the veto. School special needs are limited to teaching kids how to think, not what to think. I welcome your questions.
Counsel, you said that the schools can't regulate political or religious speech, but also that the schools can regulate speech from off campus that is directed at the school. So what do you do with political or religious speech that is directed at the school? You know, a sign a student is carrying around off campus that says don't approve the school bond funding referendum. How do you balance the one situation against the other?
Well, that speech would not come within the school's regulation even remotely, because it would fail both Nexus and Tinker. It fails the Nexus case because it's not directed to a school audience, that's the public, and it has nothing to do with a particular school. It's just not a school topic. So under our approach, and I think this is the government's approach too, it's identical. You go to 2 steps, either of which is easier for a court to handle in terms of protecting free speech. 1, make sure the audience is the school and the topic has to be about the school. And if it's easier, go ahead and jump to Tinker and say that no matter how much offense someone takes to that speech, that's not a substantial disruption just because listeners are offended.
Let's say that the protest...
ate that question up. She ate that question like it was lunch right there. She was ready for that one.
It's almost like she's prepared. It's almost like she's done, model arguments before.
She was like, "Yo, this ain't gonna." Thing. I love the way she's like, "It's not gonna work." Why? Because our test says it's not gonna work. She took it. Yeah, she ate that question. Yeah. That's how you do it. It's a masterclass.
Yeah, I did like how she started off basically saying how there's a way to put a box around this new rule that she wants to have. There's a way to sort of put limitations on it, because that's obviously going to be one of the big questions here is like, well, I mean, if you can regulate your students' speech in social media off campus, then how far is that going to go? Because social media is pretty much everywhere, right? And then, I mean, does that basically mean that schools can then regulate pretty much everything that students say off campus? So I like the fact that you're right. She's very prepared. She's come with guardrails that she's ready to put up, etc.
I think the box that she's just placed up is this about directed at the school and about a topic related to the school. So that's her way of limiting it. So you can say, she can say whatever she wants. But if it's about the school, targeting the school audience, now that gives us our first step to go in and tinker. And I think it's smart because it's a self-limitation, even though I don't think the court's going to go for it. I think it's going to go with 9-0. But it's a self-limitation, I think, in the law.
Yeah.
Yeah, and then even with that test, one wonders implicitly how this is directed at the school, the speech that we're concerned about, because I mean, it was on Snapchat, and presumably some of our friends who happen to be school members, school students, go to the school, but it wasn't like the school wasn't tagged, it wasn't directed at them, was it?
Yeah. So. And then there's a question that, if they disagree with a certain policy that the school has and they want to speak out about that policy, then are they also going to be limited on that? Because that's directed at the school too.
Right.
Good
So,
point.
but it's not, I think that the more granular distinction here should be not necessarily that it's directed at the school, but it's directed at a student or directed at the student environment in particular. Like I really think that it should be something that has an impact on the way that students learn. Like that's ultimately what's most important here.
Yeah. Good point.
So
Just don't approve the school referendum because this school is awful, or because Ms. Johnson is teaching at the school. And it's put out by somebody on there as a Snapchat, so it certainly reaches the school audience. Political speech that's directed at the school.
Yeah, so you can have, that would be a school audience, and it's Ms. Johnson is a school topic, so it's a nexus test. And the reason why that could never satisfy Tinker,
Limitation.
And that is because if it's just a ligger's reaction, speech that's critical, even ridicule of a school, schools cannot punish it because of their offense or their reaction to it. They could punish the manner. So in other words, if a female is to teach, but she's entitled to her views and to express them.
Thank you, counsel. Justice Thomas.
Thank you, Mr. Chief Justice. Ms. Blatt, how do you separate that? What if a...
This is the second time I've ever heard Justice Thomas ask a question at the Supreme Court.
He's been asking questions all
What
the
the
time
hell's been going on?
He's been asking questions every time now that they went to this segmented session where every justice gets a turn. So he's been asking questions for like the last 3 years, man.
Because for like there was like a 10 or 15 year stretch where he asked no questions.
In 10 years he asked like 2 questions. But now that they went to this format where every justice gets a set 2 minutes, he's asking questions all the time. You can't shut him up now. He loves it.
Go ahead. Well, let me at least hear the man's voice. I've never heard of
that. Said some of those same things that the Chief Justice posited, but in a social studies class. How would you separate that from just participating in class, or as opposed to doing the exact same thing or saying the exact same thing off campus?
Yeah, so Tinker, again, assuming it fits the nexus test, Tinker is always going to be context specific, and whether teachers or school officials can forecast a reasonable disruption depends on when and where the student speaks, how many people hear it, and what the student said. And when and where in the classroom is going to be very different as opposed to a sleepover. But now when it's on social media to 200 people or even 1,000 people, there's no question that the effect might be different. But
what if it's a really big sleepover?
Yeah.
Really big.
I was thinking the same thing. Or like, what if they decided to have, I don't know, like a student rally, like that's like a school sucks rally that's outside of school on a Saturday, completely like it's just down the road somewhere. I mean, and no social media for it, but they just decide to have this rally where they just rail against the school.
And in this rally, because it's our hypothetical and we get to control reality, the newspapers show up and they take pictures and they write editorials about it. And it's on the radio. And maybe the local TV station makes a report about it. So, hey, because but in this pre-internet era, is that suddenly different now because the internet's suddenly involved?
So, but essentially, so now you're saying it satisfies the nexus test, right? About the school, blah, 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 blah. So now, does it satisfy Tinker? Is it disruptive? Because she's saying to even get the Tinker, you got to get through the nexus test. So essentially, if you're saying, if you guys are saying, whatever happens, it satisfies the nexus test, can it still be held accountable under Tinker? And that's what she's limiting this to. She's saying, no, under Tinker, this doesn't work. Yeah. So even if you survive the nexus test, you still lose on Tinker.
Yep. In your case, if you want to say, Ms. Johnson, you're a terrible teacher, she should do that in office hours or on social media, not in the middle of class. That's disruptive. Can't do that. That interferes with the instruction of the classroom.
So you did say, you mentioned context, and you said that, well, the sleepover is different from school, or you suggested that. And then you did mention social media, but aren't we at a point where if it's on social media, where you post it on social media, it doesn't really matter? You could do it in class, algebra class, or you could do it at a sleepover and say the exact same thing about Mrs. Johnson. So how would that make any difference where you post it?
Well, that's precisely correct. When it comes to the internet, things like time and geography are meaningless, and it makes absolutely no sense whatsoever to say that the same speech is somehow within the school's regulation if it's 1 foot on campus or 1 foot off campus or at the Starbucks or at the CVS or in your car or on the school bus. The internet is ubiquitous. It doesn't have a geography.
So why does it have to be about the school? Can't there be comments about other hot button issues or about current controversies like protests or Black Lives Matter, Antifa, or Proud Boys or something like that? People can take sides that are just as disruptive in the school setting as comments about Ms. Johnson.
The difference is from Tinker itself. Schools are not in the business of teaching kids what to think, Justice Thomas. You're entitled to think whatever you want about Israel or race or Black Lives Matter. Now, it's a different thing if you take something that's political speech, like the Confederate flag alone, it communicates nothing. But if you take that speech and terrorize a black student with it, then the message is, I don't want you here at the school because you're black. That's very different than just the Confederate flag standing alone. I don't know what that communicates. I need to know.
One wonders if a student wore a Confederate flag T-shirt to school that had literally no other words on it or anything, if the school would really say, well, I don't know what this communicates. Could mean anything. I have no problem with that, right?
Right. But that distinction also seems to suggest, this is, I don't know, maybe I'm just looking for confirmation of what I'm already thinking, but I would think that would seem to suggest that you need more granularity for the limitation, right? That like it shouldn't just be, speech that's directed at school, but speech that's directed at a student, because that's what she's distinguishing there. There's speech is just a symbol, it's a Confederate flag, but once you direct it at a student, that's when it's problematic.
I also am going to just comment in advance about this line that's coming up in 3 sentences where they're going to use the word gulags on campus. This is great.
Or about context, but it's inconceivable that talking about a wide variety of religious or political speech, unless you take it in a way that uses that as a weapon to terrorize a particular student or teacher, it is off limits. It has been off limits since 1969. And the other side is just wrong to suggest that schools somehow are the gulag on campus. That has never been the rule since Tinker. And in 2001...
Justice Breyer? Good morning. I read Tinker, and Tinker seems to say that in the context of a student protest, in school at least, school, you cannot punish this unless there is material and substantial disruption or you invade the rights of other students. You cannot. It doesn't say if it does those things you can punish it. It says you can't unless. And the issue here seems, does that apply off campus? Well, why not? After all, if I look at the case here in the record, is there in the record something that shows that what this young woman did? She used swear words, unattractive swear words off campus. Yeah. Did that cause a material and substantial disruption? I don't see much evidence it did. And if swearing off campus did, my goodness, every school in the country would be doing nothing but punishing. And it certainly didn't help others. Disrupt others. It didn't hurt others as far as I'm aware. As far as I can see in the record.
This is what's called cutting through the bullshit, right?
Yep.
Just cutting right through the bullshit. Let's just call it what it is.
Right.
Yeah, this didn't cause any problem on campus. All the problems seem to have been caused by the school and by the coaches. They seem to cause all the problems.
Yeah, just cut right through all the bullshit. Like, listen, we understand all the hypotheticals, but let's just get to the brass tacks of this shit.
Yeah.
So why isn't that the case? Sure, if you exceed Tinker, unless you meet Tinker, you can't punish it, at least in the context of protest. And here, pretty clearly, It didn't satisfy what Tinker says is necessary to satisfy.
So I think it's fair to have the approach that the concurring judge did below, which is, I don't really need to talk about any of this because the school failed Tinker, but the Third Circuit said it was dispositive. It didn't matter what she said. She could.
Yeah. I was like, the bagger was like, yeah, like the other judge said that. Don't worry about it. That's exactly what you're saying.
Yeah.
We've done this to 1,000 people every night of the season.
All right, you want to review the Third Circuit. That's what's mystifying me. The Third Circuit says Tinker doesn't apply. If Tinker doesn't apply, they can punish more, not less. Because Tinker puts some limits on what you can punish. In school. You'd think a fortiori outside of school.
You see, I don't really buy that conclusion. If Tinker doesn't apply outside of school, then I'm not sure how it flows that you can punish more. Because Tinker is at its core like you don't give up your rights at the schoolhouse gates, which implies that you have the rights outside the schoolhouse gates.
Right.
So Tinker sort of only applies in the schoolhouse gates or by extension in school activities, in school, environments, in school blah, blah, school sanctioned events. So I'm not quite sure how Breyer gets the conclusion, well, if Tinker is irrelevant outside the school can do whatever it wants.
Yeah, because don't forget Tinker limited the school from being able to punish the students with the armband, right? Tinker can't do that. So they're saying if Tinker doesn't apply, that doesn't limit the school. That
would somehow imply that in Tinker the unspoken conclusion was you couldn't punish them for wearing the armband in school. But
Correct.
Because Tinker doesn't apply outside of school, you could surely punish them for wearing the armband outside of school
and that's
on their
what
own
he's saying.
time.
And that's exactly what he's
that
saying.
doesn't make any sense. So Breyer's theory of, well, Tinker doesn't apply, I can do whatever the hell I want. I'm like, I'm not buying that flow.
Yeah, but he's saying that facetiously, right? He's not saying that as serious. He's saying,
I don't know, man.
It seems to me he's making fun of the point, right? If Tinker doesn't, if you're saying this, then Tinker doesn't.
I hope you're right.
I
hope you're right.
Yeah.
I didn't read that way, but I hope you're right.
Yeah, no, I mean that's what I was going to say. So for Tinker, I mean it's really important to understand the language of the holding too, because Tinker doesn't say you can limit student speech so long as it's disruptive, right? It says you cannot limit student speech unless it is disruptive. That is the only situation, so it's a very, very limited way that schools can do that. So I understand that. I feel like I understand what Breyer is saying here is that he's saying that, if you say that Tinker doesn't apply outside of the school for students, then that means that you don't have that very narrow limitation. So
maybe you're right.
Yeah.
Maybe it's because I just don't like Breyer. I read it with a much more skeptical eye. That's totally possible. It goes to my biases.
Is it just me, or does he remind you guys of Jeffrey Tambor? Every time I see him talk, I'm like, I think of Jeffrey Tambor, the actor.
I hadn't really gotten that, but I'll have to go back and check.
Okay, so it's just me. Never mind. Carry on. Let's go.
So what is mystifying about the Third Circuit and the other side's brief is that we think Tinker faithfully applied, and this court has not had a Tinker decision since Tinker. So I think it would be helpful to explain that substantial disruption can't be a direct but-for causation. But more to your point, they say schools can do whatever they want under 5 separate doctrines. They say, look at strict scrutiny. Bullying, I don't know what they say. Extracurricular, I don't know what they say either. Maybe there's a conduct exception. And also threats, but let's adapt all of this for the kid environment. Tinker has been a familiar test for 51 years. And it is, in this case, I don't think it's that difficult. The question is here, she targeted her coaches, the sport, and another teammate's ability to play, and the coach reasonably forecasted someone who berates with a profane gesture and a word. All 3 of those things is not somebody you'd want at the bottom of the pyramid, and the record was not just the swearing, but it was disrespect for the coaches and the entire team and her teammates in connection with the swearing.
Justice Alito?
Ms. Blatt, I understand you to say that schools cannot discipline a student for things that the student says outside the school, not in connection with a school program about subjects such as politics, religion, morality, economics, etc., etc. The problem is when the student says something that implicates those subjects but links it in some way to a student or a teacher. And what you say is, and the Solicitor General makes a similar argument, it matters whether the speech targets the school. I have no idea what it means to target the school. Well, let me give you an example to make this more concrete. And since Tinker occurred back during the Vietnam War, it will relate to that. So during the war, a student says, the war is immoral, American soldiers are baby killers, I hope there are a lot of casualties so the people will rise up. Even if that would cause a disruption in the school, I understand you to say the school couldn't do anything about it. Is that right?
That's correct. That would be a heckler's veto, no can do.
All right. So now the student says exactly the same thing, and he adds, quote, our classmate Johnny Jones' brother is one of those blankety-blank baby killers. Can the school do something about that?
So that would turn not on, obviously, where, if it's on the internet, the location. It turns on, I think, what the Third Circuit originally said in Sachs. Obviously, it was a decision by you that says there has to be a line drawn between somebody.
It's always nice when you're citing yourself, right?
Oh yeah, no,
it's like, who wrote this? Oh, it was you. So here's what you said.
but you see what? For all you want to be lawyers in the chat, this is perfect right here. She's giving him. She said, "This is what you said. This helps my point. It's what you said when you were on the third second." Yeah, so she's throwing it right at him. This woman has done her research.
Yeah.
Taking offense and an actual objective interference with their ability to educate. I'm not sure your example would, but that's what schools have to face every day. When you insult someone, okay, that was not nice, your feelings are hurt, we need to have a conversation.
That's where that is where I think there is a problem, because when you tell me that one of the other very able attorneys says it's context specific, it depends on the facts of the particular case, there are a lot of things you have to consider. I'm really worried about how that is going to be implemented. I think if schools are going to have any authority under Tinker outside of school, there has to be a clear rule. That's what 100%. I'm looking for.
Preach that.
Sure. The clear rule has been, I think, under the law or policies in all 50 states, and it's certainly in written statutory law in 26 states, that the standard for bullying is severe, persistent harassment that actually prevents that child from getting an education. So being offended is irrelevant. You have to it has to be very severe and persistent.
But here's the thing, like, if you are meeting like one of these external standards, like, well, if you're saying, okay, it's codified in law, this is bullying or whatever, then why even deal with the issue of internal school discipline at all? You know, if the issue is harassment, if the issue is criminal harassment or whatever, the issue is whatever, you know, there's remedies in civil courts, there's remedies in criminal courts. You know, maybe this is not an issue for school discipline. Maybe it's not outside your jurisdiction. Talk to your local DA, maybe. I don't know.
Just a rebuttal to that, though. I think that she's referring to certain statutes that actually require schools to address it.
Yeah, I think she's right.
Yeah, because I think there's actual federal regulation requiring schools to respond to bullying and discrimination.
I withdraw my comment. I withdraw my comment as ill-informed.
No worries.
Well, I just don't understand what that means in concrete terms. I'll give you another example. My time is basically up. A student believes that someone who is biologically male is a male, and there's a student who is biologically male but identifies as a woman, has adopted a female name, but the student who has the objection refers to this person by the person's prior male name and uses male pronouns. Can the school do something about that?
Love it. Dead naming and referring to
nailing
pronouns. Yeah. That's a good question, man.
That's a very good nuance right there.
Yeah, I got to hear.
I think with something like a name, a school could say, well, listen, everybody is going to be called by the name we have on the school records as a matter of decorum. We're going to do that. And if they want, they can just accommodate the person by saying, why don't you just call him, her, Johnny, or whatever the name is, and just use that and say Johnny's book. I think you just accommodate. But to answer your question about being That's why Tinker's been around for 51 years. The federal government has like 10 federal agencies that deal with this. Schools have to deal with this every day. They try not to make mistakes while keeping kids from killing themselves because they're bullied.
All right.
I'd like to also at this point cite my thing from Monday where that decidedly did not go well in Cincinnati. So,
Yo, she
where was that?
Yo, if you think about it, she didn't even answer the question.
No, she didn't.
Right.
She totally sidestepped it.
Right. That was a little bit of a whiff right there.
We have a couple of
it
people
also was
heads
contrary
that
to that
told
professor that was just decided by the court, which I just discovered last week or covered last week, where there was that university professor who offered exactly this compromise. Like, I'll just call them by their name, and the university didn't allow that for that person. That went up to the Court of Appeals. So, even the compromise this person's proposing was exactly the same compromise that professor proposed in a college environment, and that didn't fly. So, hey, just saying.
Really, what he was going for was, what's the kind of policy that schools can walk away with in this sort of a situation that they can apply. But she basically was like, well, this is how I would resolve it, and that's not answering the question.
She resolved the factual issue, and not the legal issue. She was like, we're gonna hold hands and sing Kumbaya, and put the name on the record, versus how do you resolve the legal tension here? So
yeah.
Thank you. My time is up.
Justice Sotomayor?
Ms. Blatt, the problem that I have with Tinker is that I'm not sure it's any clearer a rule than any of the others that you're criticizing. Let me start with just this case. Can you punish the student for cursing at home?
Absolutely.
Or at her parents? At home?
Absolutely not, nor could you do that.
Can you punish her for cursing in her conversations as she walks to school?
Absolutely not, although under respondent's test, I guess you can. But absolutely not.
All right. Now, if you can't punish them for doing that, you're punishing her here because she went on the internet and cursed and used a curse word related to what? To her unhappiness with the school and cheering, right?
Yes, she berated her coaches, the sport, and other teammates.
Well, we could quibble with that, but my point is, I'm told by my law clerks that among certain populations, a certain large percentage of the population, how much you curse is a badge of honor. That would surprise many parents. However, if it is true, where do we draw the line with respect to it targeting a school? Kids basically talk to their classmates. Most of their conversation is about school. Most of their exchanges have to do with their perceptions of the authoritarian nature, their teachers and others. And why isn't this any different than just that the coach of this team took personal offense?
So
she spent a few minutes talking to students, reporting this incident. How is that a substantial disruption, number one? And how is this, the nature of this speech, such that it intends to provoke disrespect when she put it to a page that was supposed to disappear, and it was only a classmate taking a snapshot who showed it to anybody?
Objection, compound question.
I'm not impressed with the snapshot defense.
I'm sorry, Nate?
I said objection, compound question.
Yeah, I don't think you get to do that at the Supreme Court level. I think you just have to press on.
Snapchat defense, because she could do the same thing to 1,000 people and say, oops, it disappeared, and I'm going to do this every night to my coaches. They don't like it. It's disrespectful. My teammates are afraid of me. I don't really care. And the answer is because she's a cheerleader, and it's an extracurricular program where she consented to an extra degree of regulation because she's a school ambassador. It's a self-contained program that teaches not just teamwork, but respect for coaches.
Counsel, I note that the school's ban on cursing is only during the school year, and you did not rely, or your teacher did not rely on that prohibition of cursing in its punishment of her.
Right. These are all fair points, and what was argued in the district court. I will say the district court said it was pretty much fatal to Tinker that she said it off campus. And with all respect, that is a silly, arbitrary, unfounded, has no basis in any common sense. It would be, all of a sudden it mattered if she had sent it from the school parking lot, and all of a sudden the school could look at it and apply Tinker, and we would be having the same conversation in a Supreme Court case. But the fact she sent it at the Cocoa Hut shouldn't matter into the analysis.
Now just let me just make sure this is clear. What the point is here is that there's a jurisdiction. This is really a jurisdictional issue, like I mentioned before. Tinker only applied, and as Kurt was saying earlier, you don't lose your constitutional rights at the schoolhouse steps, right? Because Tinker was a way to kind of curtail that. The school's jurisdiction is within the schoolhouse steps, on school property, at school events, that type of thing. But when you leave school property and you're with your parents, that jurisdiction changes. They lose jurisdiction over you, and the parents have now jurisdiction over their children. So if you were to do something wrong at your home, the school is not the one that's allowed to punish you. It's your parents. They have that right to punish you, to do whatever they want. So now there's two issues here. One, where does the school jurisdiction end? And two, when do the parents' rights act? Is there any point where the parents' rights actually infringe upon the school's rights infringe on the parents' rights? I don't know why I couldn't say that. Go ahead.
Yeah. Oh no, I was going to say that although the exception that they, as we mentioned before, that they can regulate a student's speech at home so long as it has to do with bullying or harassment or discrimination. So, that's something that I think most people would probably agree on.
Yeah, and they even said that's even instituted in most of those places by statute, right? There's statutes that say you can do that. But I think the limitation here is the schools, like you're saying, school's jurisdiction is Tinker on school grounds, bullying off school grounds, because that's a little more extreme. But then everything else is really within the purview of the parents. Does that make sense, Kurt?
Yeah.
Oh yeah, but we're well beyond school boundaries, because by this logic, we could talk cross county boundaries, state boundaries,
you could be in another country.
Boundaries. There's no limits.
You could be on Mars.
This is some real extraterritorial shit that's going on right now. Suddenly, the school has more power than the U.S. government does.
You said something bad about the school from South Africa?
That's right.
Forever.
I also point out the I don't know if it's irony or not, but presumably, if I'm the parent of this daughter and she comes to me and I decide I want to make this Snapchat message, I'm an adult. I can do whatever the hell I want, because you can't push me.
There actually, there's case law saying that that schools can regulate student speech in a way that normal adults can't be regulated, right? So that's why they can regulate speech on campus that's lewd or lascivious or that kind of thing. So
I'm gonna start a completely new legal practice. My completely new practice is I'm gonna literally be the mouthpiece for all under 18 students everywhere, and I will say the things that you can't say.
But isn't that because of the transfer of guardianship? There's a transfer of guardianship between the parent and the student, like every day, right? You give your students to the state, and they strain you, blah 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 blah.
Yeah, so that idea. I don't know if it's still floating around. This in loco parentis thing. I don't know if that's really still a thing or not. Roberts mentions it, but I don't know how that much is really a thing anymore.
Well, in the sense of that's exactly they're having the ability to discipline your child and all these other things because you give up those rights to those people for that limited amount of time, and that's why I think the tension is here. Does the school, are those rights so expansive? Because eventually what they're saying is the father's right to punish his daughter. He may not want to punish her at all, right? He might have said, so what? They are now infringing on his rights to raise his child. And I think that's actually an issue, an actual live issue here.
What if one of these schools has a very pre-law club and they want to join us on a stream about talking about some issues? Is that something not a problem? Because I don't know how this works, It's all weird.
Justice Kagan?
Ms. Blatt, it seems to me that your argument that Tinker is the entire analysis may depend on a version of Tinker that the lower courts really have not adopted. Because you say that there can't be any regulation of political or regulation of religious speech, but I'll just give you two cases. One where there was a ban on shirts saying "we are not criminals" to protest an immigration bill, another a shirt saying homosexuality is a sin. And in both cases, the court said Tinker allows the school to say that you shouldn't wear those kinds of things to school. Do you think that's clearly wrong?
It's not. I thought I'll defer to you. I thought that homosexuality is a sin was fine. The border shirt or the we are not criminals was a fight where there was basically a match that was supposed to go off, and when dueling factions are wearing dueling shirts, where gang fights or fights are about to break out, and there was a big dissent and concurrence.
Yeah, so I guess
this is the strangest gang fight ever. We're going to have a gang fight over whether or not we're criminals to protest immigration.
We are not criminals, but we're going to prove we're criminals by having a gang fight.
So the school absolutely cannot touch political speech unless there's dueling political messages that are about to do some Sharks and Jet style. Okay, these are new lessons we're learning every day.
That's what I'm asking about, Ms. Blatt, because I would have thought, maybe I did get that holding wrong, but I would have thought where students say we're going to come in with the Confederate flag, or we're going to come in with... and
I know this might be slightly off topic, but I believe I'm correct that there was at least one school who actually punished a student for wearing an American flag shirt or other clothing because it was some sort of Hispanic Heritage Day on that particular day or whatever. And they actually punished the school for wearing some American flag regalia to talk about political speech. So
no,
I don't think I'm making that up.
Here in New York, there was a teacher who didn't say the you know how at graduation they sing what's it called, the Star Spangled Banner, or what is it?
Yeah,
whatever they do.
Sure.
But anyway, she said that she stopped them from doing it because she said some other, because we have a lot of immigrants here in New York, they may feel offended. I'm like, how would they feel offended from the they're the United States, how would they feel offended by the U.S. flag? What the hell's wrong with them? So I don't know.
Yeah.
You are in America.
Black Lives Matter, or homosexuality is a sin, or gay pride, in ways that the school thinks is going to cause disruption, that the school can ban those if the school is right about that. That where those symbols or speech will cause severe disruption, that the school can say, no, you can't bring your Confederate flag to school tomorrow.
So no, I think the actual opposite is true. If you look at the school handbook that we cite, and the New York school handbook says the same thing. The leading case on this is Katie versus Fillmore. It is a brilliant case where the T-shirt was abortion is homicide. Teachers, kids having abortions were upset. They said it was false because abortion is actually legal. And the school said, get over it. He's passively wearing the shirt. He's not terrorizing kids with it. He's going about his day. Leave him alone. And that case is cited as the gospel case for heckler's veto. Now, so
you're saying, Ms. Blatt, that what we should do in this case is just make courts clear, tell courts, look, Tinker is it. It's it on campus. It's it off campus. But in applying Tinker, you have to allow religious and political speech, no matter how disruptive the school it will be in the school.
Unless, as that Sachs opinion says, and as all of the Confederate flags say, when it is used in context to terrorize a student.
A particular student, right. But it can't just be we're all bringing our Confederate flags to school and it's going to cause a riot.
So if there are gang riots, and those cases are all dealing with the Confederate flag is being brought with the backdrop of race riots. There is no question that is like a fighting word in context, and fighting words aren't protected.
Well, now I don't know what you're saying, Ms. Blatt, because first you said a school can't prohibit Confederate flags, even if they're going to be disruptive, and now you say they can.
So the difference is, when we talk about disruptive, it's a misnomer. You cannot ban T-shirts and symbols because people are offended or they threaten to riot. Now, you can, in context, if you have a very extreme situation where really the facts are a new black kid arrived at school and they raised the Confederate flag.
Okay, thank you, Ms. Blatt.
Justice Gorsuch?
So political speech isn't okay. Yeah, I'm having trouble extending that thought.
But she's saying she's giving you the extreme example and saying in those extreme examples, we would allow the school to regulate. but in every day, somebody wears it's almost like if you think about the situation, just imagine one kid wears a Confederate flag shirt, and it's just like, let him do whatever he wants, let's leave him alone. But let's say now you have, a whole bunch of kids and they're doing it for racist reasons. Then she's saying, yes, you can stop that. But Kagan is like, well, how do you determine which is the more serious ones and which is the less serious ones, right? If the school gets to determine which ones we're able to do, then you're really giving the schools all the power, right? You're not really giving, if the schools can determine what's offensive and what's not offensive, then that's just giving them all the power to make the decision.
Yeah. Okay.
But then again, I mean, schools can regulate a lot of the stuff that Ms. Blatt is saying that they can't, right? I mean,
one would think, and they have regulated it. So
right.
Yeah, that's exactly the problem. She's saying things that
I'm having a hard time with
contra.
that.
Yeah, I agree. She's saying things like schools can't regulate this. And I'm like, not only can they have, unless you're saying all those are. And like, well, maybe those are okay because of particular extreme situations. So we're back to it's you can't ban someone from wearing the American flag shirt unless it happens to be Cinco de Mayo or whatever, and it's Hispanic Heritage Day. Then it's okay to ban the American flag shirts because then that political speech is contra to, I don't quite
it doesn't
know
make
the
any
next step
sense.
of that analysis
It doesn't make
is.
any sense.
Yeah, and the next step of that doesn't quite flow for me.
Let's see what Gorsuch says.
Yeah, I'd like to pick up where Justice Kagan left off.
I'm confused.
I'm confused. You started off this presentation by saying political and religious speech are absolutely protected. But I think in response to both the Chief Justice and Justice Kagan, you've suggested that there may be limits there as well. Can you explain what your test is?
Yeah, the only limit is where that I've seen in any of the case law is where there are race riots and gang fights and student walkouts. You have very disruptive, volatile environment in the school. So none of this applies to anything to do with the question presented. But
so it is a major disruption test with respect to political and religious speech as well.
It is a major disruption test that takes out the word just because students are offended and feelings are hurt and you're very angry about the speech.
Her test is
No, I understand offense isn't enough, but if there's a major disruption, that is enough.
It's a major disruption with reasonable. Just because kids say, Miss So-and-so, we're gonna riot if that kid walks in with a Confederate flag, then you suspend the kids who threaten the riot. You don't suspend the kid with the Confederate flag.
Sure, but if the school thinks that that the kids are reasonably reacting to offensive political or religious speech, then it can address that issue.
I would say not offensive. I would use the word terrorizing.
Terrorizing.
Okay. Terrorizing.
Terrorizing speech is a slightly strange concept.
Yeah, I like when he said terrorizing. I'm terrorized. He's like, what?
Yeah, maybe. Yeah, what is terrorizing speech legal? You got anything there?
I mean, that's a new concept.
Okay.
Homegirl's I'm going to say this. Homegirl's going down in flames right now. She's going down.
Well, yeah, she's having problems because she's running into problems with her test. The Supreme Court is poking at her, and she's running into problems. She's like, well, the political speech is absolute. Oh, wait, maybe it's not. Oh, it's this way, but maybe it's not. She's running into problems.
Pilot. She's a kamikaze pilot. Just ran out of bullets and realizes the plane is the only thing left. You know what I'm saying?
Yeah. So she's trying to uphold something here, and they keep testing her borders, which I was been trying to point out to the chat, and she's trying to defend it within the borders of what she's trying to do. So people are asking these extreme questions to try to poke at it and see, well, what would be okay, what's not okay. She keeps trying to answer questions, and she winds up in logical paradoxes because it
really has to be terrorizing.
And the ultimate thing here is the way that the school is making this argument, it's not even about the speech. It's about the specific medium. So you could make a credible argument. This isn't really, strictly speaking, a freedom of speech case. This is a freedom of press case, if you want to be really technical about it. Because it's not that you can't say it, it's the medium. So it's like if you can say it, presumably in a newspaper, but maybe not the school newspaper, on the radio and the local news report, but on the internet somehow, that's completely different because we can talk to a whole number of people. Even if I have even if I'm the most popular kid ever, I have a huge party and I say it at my huge party, that's different. Where is it?
Yeah.
So the boundaries are very clear here.
The question too then also is, so she was in control of her Snapchat, but what if someone else recorded her saying that? and she didn't have any control over that publication.
This is a good point.
That's a good point.
This is a good call.
But
I
would think that you couldn't hold her accountable then. I don't think the school could punish her, because then that
oh no, she was still saying unsportsmanlike things. I mean,
but she did.
She was an ambassador to her school, right?
That's true. Yeah. I don't know. Under this test,
we take that school pride thing really seriously here. We're really serious about the school pride.
But the thing is this test now? What Gorsuch has done, which I think he's done brilliantly, is made it now undefinable, right? Because we don't know what terrorizing means. She just threw out the word terrorize. We don't know what that means.
Yeah. It's not if it's offensive, it's terrorizing. Oh, terrorizing speech.
Yeah, and then he even said terrorize, at this point it's done. But I think she needs to kind of go back to what is she actually arguing? Is she because she's saying the jurisdictional issue doesn't matter. It doesn't matter if you're on school grounds, no matter where you're at.
Her position appears to be anytime, anywhere, 24/7 if it's disruptive to the school, whatever the hell that means.
And we know that's too expansive, and that's where I think they're getting to. And then when she's becoming arbitrary with the examples, here I don't know, it's got to be terrorizing. Your
cat's trying to terrorize in the background.
I know. Right. I was just about to say this is perfect timing because he was named after Justice Holmes, so of course he would cameo during a live stream about free speech.
Brandeis or bust.
Oh, it's not.
Does it make a difference that this case involved an extracurricular activity?
Yes, with respect to the application of Tinker, because of what I said about the goals, and you can offend and destroy the program without affecting the school at large. So here, the student was not in any way, there was no disciplinary action taken with respect to the school. She was suspended from the cheer team, and I think under the other side's view, she couldn't have even been asked to write an apology or suspended for one game. And she could do this every night. As long as she waited till the Cocoa Hut to do it, she could berate her coaches all day long. And I think that that's very different. If students want to use swear words, even on the internet, that's fine. And they can do it with respect to teachers, too. It's going to have to rise to the level of harassment.
Which somehow this did.
Yeah.
It's one post.
One question that I have is, was that not the whole statement? The F school, F this, F that?
Yeah, there might have been some other things, but that's what they went after her for. That's what they disciplined her for, yeah. So there might have been some other background stuff because they keep referring to these other things that were happening. But none of them are material to this case.
Yeah.
They want to get her for this one chat.
Well,
give the auto transcriber a break, man. I corrected it for my part. Give it a break.
It is an AI.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Ms. Blatt. I want to focus on the facts of this case a bit and my reaction to it. As you say, and I think helpful for you, the context here is a team and a coach, not the school more generally. But as a judge and maybe as a coach and a parent too, it seems like maybe a bit of a overreaction by the coach. So my reaction when I read this, she's competitive. She cares. She blew off steam like millions of other kids have when they're disappointed about being cut from the high school team or not being in the starting lineup or not making all-league. And just by way of comparison and to show how much it means to people, arguably the greatest basketball player of all time is inducted into the Hall of Fame in 2009 and gives a speech. And what does he talk about? He talks about getting cut as a sophomore from the varsity team. And he wasn't joking. He was critical 30 years later. It still bothered him.
That's Michael Jordan, right? They're talking about.
Yeah, Michael Jordan. Yes,
yep, of course. So. Who else would that be?
Well, I just want to double check.
The greatest basketball player of all time, LeBron James.
And I think that's just emblematic of how much it means to kids to make a high school team. It is so important to their lives, and coaches sweat the cuts, and it guts coaches to have to cut a kid who's on the bubble, and good coaches understand the importance and they understand the emotions. So maybe what bothers me when I read all this is that it didn't seem like the punishment was tailored to the offense, given what I just said about how important it is and how much it means to the kids. A year suspension from the team just seems excessive to me. But how does that fit into the First Amendment doctrine, or does it fit in at all in a case like this?
Well, I don't think it does, because it's analytically distinct whether the coach could act at all versus due process considerations about the extent of the punishment. And I think the rule, and also this is the remand point. The district lost on this issue, and the Third Circuit did not go on this rationale because there was evidence of the team cohesion. But I think, whether I understand that Michael Jordan was upset, but at some point, presumably, he was respectful to his coaches. And there's a line that coaches always have to know their team and know what works. They have to act in the best interest of all teammates, team participants. And one of the things you learn
in the moment, that kid's going to be upset.
Can you stop it?
Sure.
Did she just flip the Michael Jordan hypothetical around? Hardcore?
I don't know whether or not Michael Jordan was respectful to his coaches in the moment or not.
That was beautiful.
I think there's a pretty decent probability he might have had some choice words to share at the time.
Probably. I mean, based on the way that he, what we know about the way that he would rib other, players on his team for not working hard or whatever. I don't know. Yeah, I don't know.
But the fact that she threw it back at him, he's like, the greatest basketball is cut from the team. He said, but he respected his coaches.
Maybe.
Yeah, that's why he's being inducted into the Hall of Fame. It's definitely the issue.
Oh my gosh.
You recognize that. I'm not saying this is justified necessarily. I'm not, but a year seems like a lot.
Well, again, then you're going to be in the business of.
I agree. That's the problem. I agree. On the legal issue, the do no harm. I think legally speaking, we should try to do no harm here. Your approach would be to just say the Tinker standard applies regardless of the precise location of the speech and just remand. Is that enough?
That's absolutely enough.
Thank you.
And I think, yes.
Justice Barrett?
Good morning, Ms. Blatt. Let's assume that I think about the case in the following way. That high school students enjoy the same free speech rights as everyone else. Tinker acknowledged that in the context of this, once you cross the schoolhouse gate, those rights are somewhat reduced because of the school environment and the need to, control and avoid substantial disruption, but they're not lost altogether. But that nothing in Tinker suggests itself that it applies outside of the school environment. And so what you're asking us to do is to extend the school's authority that Tinker acknowledges outside of the school environment. And I think you have good policy reasons for doing that. I think harassment, bullying, and I think threats of violence against the school and cheating are all things that would be of concern. I don't see a lot of doctrinal support for saying that Tinker applies, that the school's increased authority applies. Tell me what you think doctrinally your best authority is.
That was a beautiful, she put her case together. She explained the weaknesses of it. And she says, this is the reason why Tinker doesn't, I don't think it applies. But here, with all that, what are you giving me? That's how Amy Cody Barrett, I think, is beautiful. Asking, but also kids, because she's the last one to answer the questions, right? She's the last one to ask the questions to the side, so she kind of sees what the weaknesses are on the argument. But that's a beautiful question. I love the way she put her argument together.
Yeah, that she basically is like, what's why should we extend this outside of school?
Yeah, and what's your doctrinal support? Because you haven't really given us a lot of it.
Yeah,
you've just been talking shit.
Yeah. Sure. The 100 years of case law that was unambiguous that schools could regulate anything off
campus. Well, let's assume I don't think I think I read the history a little bit differently. What about in our precedent? Do you see anything in our precedent that really requires this extension of Tinker?
Well, all the school speech cases, there's only 4 of them, are tailored to the school interest at stake. And so the question is, in terms of what need to protect the school. And if we're talking about a narrow category of speech that actually, and what here is threatening the extracurricular program, so that doesn't fall into your cheating or bullying. It is speech that destroys the morality of team cohesion.
Well, but I think actually, Ms. Blatt, that's part of the problem because, you point out that the other side's test or proposed test has its problems at the edges because of the internet and remote learning and all of that. But your three-part test certainly has its own issues. It's not going to be easy to apply. And I think a lot of the questions that you've gotten today show a concern, including in this case, that schools abuse this authority and that they punish things that maybe don't cause substantial disruption or political speech or religious speech that they shouldn't. Or, I think you've heard a lot of skepticism about whether the speech at issue in this case actually caused substantial disruption. So I guess my concern is if we have two tests being offered or on offer, neither one is going to be easy to apply in all cases. They'll both have hard cases. Which one ought we apply? Which one is the more protective of speech? And let me ask you this, insofar as the policy concerns go, nothing in the First Amendment prohibits soft discipline, right? Like in this case, the cheerleader coming to school and being told, rather than being kicked off the team and punished, being told, we're aware of the Snapchat, this is not good for team cohesion, this is not respectful of your coaches. If we see any of this kind of behavior on the field or at practice or undermining morale, there's going to be a consequence. But not imposing one yet. That would be okay, right?
Yes, but there are cases where the student was asked to apologize and the student sued the coach in the school and said, I don't have to say I'm sorry. I have a First Amendment.
That's compelled speech, too, which is a whole other category of problem, right? We want to make you say something, a whole other category of problem.
And I love how she threw it right in the case. She was like, you want to sit here for that shit? You know what I'm saying? Let's deal with this.
Yeah.
Right? Not to say I'm sorry.
Okay, my time is up. Thanks.
A minute to wrap up, Ms. Blatt.
And I think this goes to Justice Barrett's question. Your choice is between the familiar Tinker standard that has applied to social media over the last 20 years. Respondents are going to regulate off-campus speech, but they send schools into completely uncharted waters by replacing Tinker with a Frankenstein's monster of First Amendment doctrines all mashed together. Respondents worry about schools suppressing too much speech, but telling schools they can regulate undefined categories of harassment, bullying, and speech inciting violations of school rules invites more suppression. Vague, unfamiliar rules don't work when student welfare is on the line. All this court needs to hold is that Tinker is not subject to a territorial switch. Under respondents' view, it would not have mattered had BL derided her team and coaches every night throughout the season on 12 different social media platforms. Students shouldn't be able to place their speech off limits just by stepping off campus.
And then I'm back to my earlier question. Would it matter if she berated her coaches every night by calling students and berating them over the phone? Would that make a difference?
Well, I think this is the problem. The problem with her test is the limiting factor. What limits does this have? And she threw out terrorism or whatever. But this really has no limits, right? Because like we're saying, you could be in a different country, for instance, and if it fits her test, then you can be punished for it. So, and how expansive is this right? Because you're giving the state a lot of right over these children. You can't say anything about the school or about the coaches, even if you're in Cambodia.
Right.
All right, let's listen to what the U.S. government has to offer as their amicus. This should be fun.
So hold on, they're on the side of the school. I'm assuming.
Yeah, the U.S. government. Right. The U.S. government wants to say nice things about the school, so let's listen to the U.S. government say nice things about the school.
Thank you, counsel. Mr. Stewart.
Thank you, Mr. Chief Justice, and may it please the court. Under the Third Circuit's approach, BL could send out snaps from her home every evening disparaging the coaches, her teammates, and the enterprise of cheerleading. Such messages from a member of the squad would have an evident tendency to disrupt the functioning of a school program that depends on and is intended to instill values of team building and mutual support. In situations like these, school officials should be able to intervene to protect the interests of other team members. The Third Circuit's rigid geographic approach is particularly unsound in the context of online speech, since there is no meaningful causal link between the place from which an online communication is sent and the likelihood that it will disrupt school operations. I welcome the court's questions.
Mr. Stewart, if you get to the point of considering whether speech is directed at a school, I wonder how you parse that, because teenagers, maybe most of their friends are also their classmates, and does that mean that anything that they generally send out directed at their friends has to be considered that it's directed at the school?
I mean, first we would say no, even for purposes of the first prong of our test, which is it school speech? But the second thing we would emphasize is that even if speech is determined to be school speech in the sense that it focuses on the school as such, that doesn't mean that the school can regulate it. That just simply means that the school should have the opportunity to make the showing that the speech is likely to cause substantial disruption of school operations.
What about speech, political speech that involves the school? Opposing a school referendum because Ms. Jones is a terrible teacher. Do you categorize that as political speech, which is off limits, or speech directed at the school, which can be regulated?
I mean, it's a little bit of both. The part that says we oppose the school referendum is very similar to the speech that was at issue in Pickering, the seminal case about the rights of public employees, and the court said in that case, because there was no close working relationship between the teacher and the school board, there was no likelihood that this would disrupt workplace operations. The part that says Ms. Jones is a terrible teacher, that might take it over the line into school speech, but a single statement like that wouldn't, in our view, have the capacity to disrupt school operations. If there was a continuing, ongoing online campaign of virtual harassment or intense disparaging of Mrs. Jones or Ms. Jones, that might be a different situation, but a single negative comment wouldn't qualify.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Stewart, thank you, Mr. Chief Justice. Mr. Stewart, should we analyze the rules of a team as Justice Kavanaugh alluded to, as opposed to the general rules that apply to the school population? Is there a difference in how we should?
Yes, I think there is. And if I could say something about a comment that Justice Kavanaugh made in the first part of the argument, I think there is in some sense an intuition that people have that the punishment didn't fit the crime in the sense that the suspension was very severe. But there's another sense in which the punishment did fit the crime. That is, BL was suspended from the cheerleading squad, not from school. If the school had suspended her from school, that would have sent the message that this was considered to be unacceptable speech from any student, and that would have been a very difficult showing to make. But the sanction that was actually imposed sent the message that this was unacceptable speech from a member of the team. And I think it's not limited to the school setting or the team setting, that people who participate in projects or organizations that have as part of their raison d'etre cooperation, team spirit, mutual support, they may have to accept limitations on their speech that couldn't be imposed on the workplace generally. For example, if I
let me squeeze in one other question. Let me squeeze in one other question real quick. When we talk about material disruption as a basis for preventing or disciplining students who engage in certain speeches or conduct, can you also localize that to the team so that if a team member disrupts the team, that it's okay to discipline that team member, even though you wouldn't normally discipline that person as a member of the student body?
Yes, absolutely. And I think it would be impossible to run sports teams at public high schools, or for that matter, public universities, if that were not the case. It happens all the time that cheerleaders or student athletes will do things that disrupt the operations of the team but don't have any larger effect on the school as a whole. And at least so long as the discipline is limited to exclusion from the team or suspension from the team, that's not a problem.
Thank you.
Justice Breyer?
As far as I can see, I can't write a treatise on the First Amendment in this case. And so at the moment I'm thinking I'm
not sure why you can't, unless you don't, you
well,
literally
get
can't
into
because
it.
you don't know it well enough or something.
You don't like Breyer.
I don't like Breyer.
He's a hater.
I don't like Breyer. It's hey, I don't like him. I don't like him. He's not my favorite guy.
only two ways of dealing with it. One, treat it as an example. We can't go beyond that. Look at the record. and then decide. Or the other is everyone seems to want some rule, and the rule, I think, might be take Tinker as if it said, which it doesn't, as if it said, school, you do have some authority where there's a substantial injury to disruption in the class, or somebody's going to be hurt in that school, etc. And I would add, but remember, it's outside the school, and that's primarily the domain of the parents. And even when it's inside the school, you're not a schoolmaster. Judge, be careful. Okay, I could say something like that. Well, what should I do?
I think the 3 or 4 things I would say are, first, no per se rule that off-campus speech is categorically exempt from school regulation. Second, with respect to online speech in particular, the location from which the post is sent is more or less irrelevant to the likelihood that it would cause disruption. Third, a school can permissibly conclude, as in the teen context, that particular speech will disrupt the operations of a particular school program, even if it doesn't disrupt the operations of the school as a whole. And fourth, in determining what counts as substantial disruption, we should look to the purposes of the program. And here, the coach testified at JA 32 that part of the purpose of cheerleading was to teach team building skills that students would take with them to later life. Team cohesion was not simply a means to some other end. It was one of the objectives of the program. And as I say, reasonable people could differ about whether this isolated snap would likely have the effect of disrupting team chemistry. But the Third Circuit's analytical approach would apply equally in a situation where BL had sent repeated snaps disparaging the coach, disparaging the team, where absolutely the predictable effect would be a breakdown in team morale.
Justice Alito?
Suppose a student says something outside of school that relates to an important subject like politics, religion, morality, etc., makes no reference to the school or to a teacher or a student, but the remarks are so offensive that they will predictably cause controversy within the school and could distract the students from the educational process. Does the school have any authority to discipline the student?
No, not on our view. And indeed, the purpose in our analytic test of having a school speech prong is simply to provide a safe harbor, to make clear that in the situation you posit, where the speech off campus has no inherent connection to the school, the justification for regulation that people will be upset when the school day starts, that's simply an illegitimate justification.
All right, so an important part of the test that you propose is whether the speech intentionally targets specific individuals or groups in the school community. The verb target means select as an object of attention or attack. So does school target an individual, a student, or a teacher whenever it refers to the teacher or student?
No, I don't think that's the case. And this is a contextual approach where you would look at the speech as a whole and ask, is this predominantly a comment about an individual, a student, or is it predominantly a comment about a social issue? But the other thing I would stress is, even if in a particular instance you get past the screen and say, this is school speech, that doesn't get the school home. The school.
Well, what troubles me is that what you just proposed is a very nebulous line. And I'm quite concerned about the effect of this on freedom of speech. I think we need clear lines. Can you clarify, can you give me anything firmer than what you just said?
I guess the two things I would say are, first, even in cases where we are applying Tinker, you should not just look to kind of the likelihood that disruption will result. You should employ concepts like proximate cause to determine if a disruption does result, can that properly be attributed to the speaker, or is it the fault of the listener? The second thing I would say is the Tinker framework in some respects will apply quite differently in the schools.
Justice Sotomayor?
Mr. Stewart, your test speaks about, I'm not sure, and I'm following Justice Thomas's questioning, seems to focus on sports teams. But one could say that about any extracurricular activity, that there is team spirit of some sort involved in science lab work, in after-school science lab work, in forensic speech writing or arguing. There isn't an after-school activity where the spirit of that activity couldn't be perceived as being impacted by what people find is unpopular. So let's get to Black Lives Matter t-shirt. How about or the Confederate flag, how about if students in any after-school activity want to wear those t-shirts? When would you say that the school could ban that?
I would say not at all, at least not on the team building concept.
But why?
That is, I think that's simply a case in which the free speech rights of the students would be paramount. That is, it is possible in theory to imagine a team in which almost all the members support a particular political candidate, and to some degree the presence of a teammate who supports the opposing political candidate is going to be a source of argumentation. But that doesn't strike at the core of what the team is about. What strikes at the core of the team
Do you agree with Ms. Blatt? If there is race tensions, any other kind of tensions on the team, that the school could intervene at a certain point?
Yes, I mean, it certainly could be the case that if people were kind of operating in close quarters and this pattern of tension was established, that might justify some form of speech regulation that wouldn't otherwise be justified. I think the Seventh Circuit in Zemesnik, a case cited in the reply brief for the petitioner, has referred to this as kind of a species of fighting words analysis. And the idea is, even in the adult context, though we don't usually look at the reaction of the speaker, there are some forms of speech that seem intentionally provocative.
Justice Kagan?
Mr. Stewart, is the speech in this case school speech?
It is close to the line because it mentions school and it mentions cheer, but it also mentions softball, that was not a school.
So which side of the line does it fall on?
I think it probably falls on the school speech line, but it's not entirely determined.
So that means really
he doesn't even know if it's school speech or not. I love that, because apparently the softball wasn't referring to school. Presumably the school has a softball team, but it wasn't referring to the school softball team. So, and also life itself isn't referring to the school, one would imagine. So I like that. He's not even sure if it's school related or not, which under his test, we're not sure if we can punish it. This whole thing is backwards, insane.
Yeah. And the thing is that he's talking a lot about team cohesion, right? And Ms. Blatt was talking about team cohesion too. That was something that is one of their justifications for their reasoning, right? But at the same, sorry, but I think that if you have any kind of major disagreements that are political in nature, like BLM versus Proud Boy, I mean, I'm not putting them on the same level, but like if you have people that, let's just say BLM,
you gotta put them on the same level, Lita. It's the only way to have fun in this world.
I'm not making any political statements here. No, but like if you have on a very controversial subject, let's say the Derek Chauvin trial, right? You have people that are very heavily disagreeing on that. If you have students on a particular team that are talking about that, one student takes one side, another student takes another side. Of course, that's something that can totally impede the school's morale, or not the schools, but the team's morale and their cohesion. So none of that seems to be a strong argument to me.
Yeah, it's a little bit weird about how you divide that line. It's only relevant if it somehow attacks the team cohesion's raison d'etre or something. But trying to figure out what that is a little bit odd or not, and would lead to some very weird results in some places.
Yeah.
If you think about religious or political groups in the school.
Yeah.
Which would also be interesting how that would play into this whole analysis world.
I just want to say I love how the cat is terrorizing Alina right now. Terrorized.
I know it's because so his name is Holmes, by the way, Holmes or Holmesy, and I feel like this is like Holmes speaking from beyond the grave.
Yes. Well, was Holmes have to write? He might have something of value to share with us.
I apologize for the errant noises and stuff. Maybe I should mute my mic.
You're doing fine.
Everything that mentions a school at all is school speech, right? Because this is pretty generic.
Well, it's not just the content that we're looking at. The speech, the snap was sent to a wide audience. It included a number of students, a number of cheerleaders. It predictably reached the cheerleading team and the coaches. And again, the fact that there may be some indeterminacy about the first prong of the test doesn't get the school over the hump. The school may still be unable to establish on remand, if the case is remanded, that this speech would have a natural tendency to disrupt team chemistry.
Can I give you a few hypotheticals and you just tell me school speech or not school speech, and let's just assume that all of these cause substantial disruption, okay? Student emails his classmates the answer to the geometry homework every day after school.
School speech.
Student emails his classmates that they should all skip school tomorrow for an impromptu senior skip day.
School speech.
Student emails that they should refuse to do any work for English class until the teacher changes the syllabus to include more authors of color.
School speech.
So that can be punishable.
If it causes substantial disruption.
Okay. Student tweets that there's pervasive homophobia at his school and that prospective gay students should stay away.
That seems like school speech, especially the last part of it, when it encourages other people to avoid the school based on this characteristic.
Last one. Student tweets that his school really stinks and students should stay away.
I think it's still school speech. It's an assessment of the school as a whole.
I will give him points for actually answering the hypothetical and not fighting the hypothetical. So I'll give him points regardless of whether you agree with the answer. He actually answered the question, which is more than you can say for a lot of people.
True.
As I was saying earlier, the principal point of our school speech prong is to provide a safe harbor for situations where a student engages in very inflammatory off-campus speech that has no inherent connection to the school. And we want to say that the school simply can't try to make the case that that speech should be regulated because of the spillover effects it would have when school reconvenes.
Thank you, Mr. Stewart.
Justice Gorsuch?
Mr. Stewart, is there anything that the petitioner argued that you disagree with this morning? And can you explain, if to the extent there is, any daylight between your test and theirs?
I don't see any daylight. The only thing I would emphasize that I don't think is inconsistent with the petitioner's presentation is that in the context of on-campus speech, the courts have applied a concept of quasi-fighting words, where taking into account the relative immaturity of the school audience and the fact that students are captive audience, the courts have allowed school authorities to crack down on a narrow range of speech that couldn't be punished outside the school, but is particularly likely to cause a disturbance in the school environment. But with that small caveat, I would agree with petitioner's argument that, in general, disagreement, even strong disagreement by the rest of the students with even on-campus speech is not a basis for regulation.
But they're not a captive audience.
You could just address more broadly.
That's true. They're definitely not a captive audience. Yeah.
That's part of the thing about regulating speech at school is that they're a captive audience at school, but on social media, they're anything but.
Mm-hmm. And you also don't want it to inherently disrupt the educational environment. So, like, the other thing would the other thing would be, what is the disruption that's occurring actually in the classroom or to the educational mission itself? Mm-hmm. Like, so if there's disruption in the halls, maybe that's not enough. Maybe we need something more. With disruption actually to the academic mission.
Right.
That seems to be what Tinker is about, right, too? It's not just enough that, there's some people that are unhappy. I wouldn't know for sure, but I'd imagine around the time of Tinker, there were some people who were pro-Vietnam War, some people who were anti-Vietnam War, might have caused some disruption, in 1960s high school America, maybe?
Yeah.
So, teachers probably had some opinions about the Vietnam War at the time.
I'm sure.
So, yeah, and so they thought that was enough because it was disruptive speech, and that's what Tinker's all about. So I don't know. Maybe we just need to reassign colors. We'll have the hot pink for F cheer, the hot pink F cheer armband. Maybe that's the key. We'll use a different joke. This is going back to what is the handkerchief code? That's old school. All right, from the 70s, man. Let's go on. Let's move on.
The thrust of the argument from the other side, which is that there's some irony in the fact that as avenues for expression have increased for all of us through the internet, this actually leads to more regulation of it by schools, and that the authority for schools, as in loco parentis, grows and reduces the room for parental control and supervision.
I think that the two things I'd say are that the internet is an extra option. People still do have the option. I mean, students in high school still have the option of doing what people did in my day. That is, express their views to their friends and classmates at parties, social gatherings off campus. That there's no requirement that everything a student thinks and wants to communicate has to be communicated to the broadest possible audience.
Ooh, that is classically a First Amendment kind of no argument from the government. It's okay if we regulate books, they still have newspapers. It's okay if we regulate newspapers, they still have periodicals. Yeah. It's okay if we regulate periodicals, they still have radio. This kind of argument is unusual First Amendment no-go.
Yeah. And the counter argument to that is, okay, but what about the fact that students in a pandemic, high schoolers are increasingly communicating socially online as opposed to in person?
Yeah.
So, I mean, do those opportunities actually exist in real life on a practical level? But yeah, no, regardless of that, your point is 100% true.
Yeah.
It's nice to get one right every once in a while.
But I think the flip side is off-campus speech has a much greater tendency now than it did then to affect the operations of the school, simply because it can be made available to a vast audience. Not with respect to the snap, it's different, but a lot of online speech will literally appear on students' phones when they're back in class at the next school day. So I don't think it would be untoward for the court to take account of that potential effect of off-campus speech in deciding what the constitutional rule should be.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Stewart. I strongly share Justice Breyer's instincts when he mentioned that we probably can't write a treatise here and shouldn't write a treatise here and can't foresee all the things that could arise and a lot of the hypotheticals that have been raised. So I just want to get your reaction. If we just simply said the First Amendment does not categorically prohibit public schools from disciplining students for speech that occurs off campus, period. It may matter that the analysis here involves, or the situation here involves a team, not just the school more broadly, period. Remand. Is that enough?
I think that would be enough. It would probably be helpful to say, with respect to online speech in particular, the location from which the speech was posted is ordinarily going to have no significant effect on the likelihood that it will cause substantial disruption. But we entirely agree that the court shouldn't be writing a treatise, and we particularly agree that this is not the occasion for the court to try to decide how the close cases involving in-school speech ought to be dealt with.
And then I think you mentioned this, but the proportionality of the sanction here that I mentioned to Ms. Blatt, I guess, how do you see that fitting in at all, if at all, to the constitutional analysis? And maybe the answer is not at all.
I think that the length of the suspension doesn't factor into the First Amendment analysis. It might conceivably be the basis for a due process claim. As I indicated earlier, I do think the fact that BL was suspended from the cheerleading team rather than from school is significant. This would be a much harder case for the school if BL had been suspended from school entirely, because that punishment would rest on the idea that no member of the student body could acceptably have said this, and that would be a much harder case. What made the speech objectionable was that it was coming from inside the team.
Justice Barrett?
Mr. Stewart, I want to go back to Justice Kagan's hypothetical about sharing the answers to the geometry homework after class. You said that would be school speech. Do you think it's speech to pass on the answer key?
Yes, I think it would be speech.
What about threats to the school? You know, I'm going to come in, I'm going to bring a gun to school tomorrow and open fire.
I think they would still be considered speech. Now, things like true threats may not be constitutionally protected, but that's not on the theory that they aren't speech. And I think it is important in the school context that you could, if you had a student who in his off-campus posts was trying to cultivate a vaguely menacing persona and was careful not to say anything that rose to the level of a true threat, but that was still intended to put his audience in fear, that's the sort of thing that a school ought to be able to regulate.
But that's also the kind of thing that the authorities could regulate if there was someone who was discovered online threatening the school or menacing the school and seeming like it could be a risk, right?
I mean, again, if the communication rose to the level of a true threat, something that could be punished under criminal or civil law, even if an adult did it, yes, that would be true. But the circumstance we have in mind is...
let me ask you when my time's going to run out. Could a school seek a waiver of First Amendment rights for participation in an extracurricular activity like cheer?
I mentioned waiver.
No, I don't think...
It's a good question, but there is this idea of unconstitutional conditions that you can't... There is limits here, and we're going to get to this idea. You okay over there, Alita?
Yes.
You have a right to school, but you don't have a right.
On the floor over there.
Yeah, it's the cat.
Okay. Kurt, I'm going to say you have a right. You have a right to school. You don't have a right to the extracurricular activities.
Well, no, I understand that you don't have a right to that, but there is an idea that the government, especially in free speech, it seems to come up a lot. They can't put like unconstitutional conditions on certain things. You see it sometimes with government spending cases, where the government tries to impose, if you accept this money, that we're going to limit your freedom of speech. So there is an idea where there's like you can't make things optional on your waiver of certain constitutional guarantees.
Well, hold on. Let's just be clear. Let's say football players, basketball players, they waive some of their constitutional rights, right? Their freedoms of speech to be on the team. They have to wear a uniform, for instance, right? That is a form of speech, even though they're not saying it, but they are wearing a uniform, right? All looking in the same way. The school compels them to do that, right? To represent the school, if you want to play in basketball, you must wear this uniform in this manner at this time in this way, and if you don't, you can't play for us. So they are compelling these students to speak. So there is some limitations to student speech, even when they do these extracurricular activities. We're just talking about what
I wasn't trying to imply there was no limitation, but I didn't want to go overbroad on the other end either.
Okay, I understand.
Yeah.
That the school could seek a blanket waiver, and so, for instance, if BL had been suspended from the cheerleading team because the coach disagreed with her political views, that would be impermissible. That would be a clear violation, even though the only sanction was removal from the extracurricular. And it would be no different if the school tried to extract a waiver in advance of the right to engage in speech that had no inherent connection to the school or the team.
Thank you.
Minute to wrap up, Mr. Stewart.
Thank you, Mr. Chief Justice. We've been discussing the school speech cases as though they were a doctrinal island, but I think it is worth pointing out that school speech is only one context in which participants in government programs can be made to accept speech restrictions that couldn't be imposed on the general public. So if I, for example, posted a message online that tracked the text of BL Snap, but instead of school, softball, and cheer, I put DOJ, law, and the Supreme Court, that would be constitutionally protected speech. But DOJ, as my employer, could certainly take the position that that was inconsistent with my job as a DOJ attorney. And that would rest in part on the fact that my employment at DOJ is voluntary on my part, but it would also rest on the fact that communications like that would have a much greater destructive tendency coming from within the department than from the outside. And the same principle applies here. Thank you.
Thank you, counsel.
His speech is restricted as a DOJ employee. Boom.
Yeah, I'm gonna take a flyer. I'm gonna take a flyer, and I'm going to assume that there has been a DOJ attorney at some time who has said some version of "fuck the DOJ, fuck the law, fuck the Supreme Court." I'm guessing that is not pure hypothetical.
Or maybe he was thinking that as he was like getting ready to go to court.
Here's what I'd really like to say. Yeah, no, I like that. Here's what I'd really like to say, but since I can't say it, I'm going to slip it into an oral argument. Hey, what are you trying to say, Bob? Nothing.
I love my job.
That's right. I love my job. No reason that example came to mind. No.
Mr. Cole.
Thank you, Mr. Chief
All right,
Justice.
so now we're finally with BL's attorney, in case you were trying to keep pacing over here. So now we're here with the poor maligned cheerleader, the heroine of our cause, our protagonist. Let's see what Mr. Cole has to say for BL. I wonder where BL's on all this thing. Bring a uniform and pom-poms in the Supreme Court. That'd be good.
Court. At its core, the First Amendment prohibits content discrimination. Its bedrock principle is that a speaker can't be punished because listeners object to his message. Tinker announced a narrow exception to those principles. It allows school officials to punish speech based on its content if listeners object or might object in a disruptive fashion, but it is limited to school-supervised or school-sanctioned settings. This court's school speech cases are called that for a reason. The authority they recognize is justified by and limited to the special characteristics of the school environment. So schools can prohibit pro-drug messages at school, but not elsewhere. They can ban profanity at school, but not at home. So too, they can punish disruptive speech at school, but not at a convenience store on the weekend. Expanding Tinker would transform a limited exception into a 24/7 rule that would upend the First Amendment's bedrock principle and would require students to effectively carry the schoolhouse on their backs in terms of speech rights everywhere they go. It would also directly interfere with parents' fundamental rights to raise their children. A father shouldn't have to worry that if he brings his daughter to a Black Lives Matter protest about mistreatment of a black student at school, and she posts a photo on Facebook, she might be suspended based on potential disruption at the school. BL was punished for merely expressing frustration with a 4-letter word to her friends outside of school on a weekend. Her message may seem trivial, but for young people, the ability to voice their emotions to friends without fear of school censorship may be the most important freedom of all. Yeah. I welcome the court's questions.
Yeah, I'm on board.
It's a pretty strong start.
Yeah. Go, Cole.
Mr. Cole, that sharp line I think you're trying to draw between on campus and off campus, how does that fit with sort of modern technology? I mean, it's if a text or a snap that you send from the park and it's read in the cafeteria, is that off campus or on campus?
So if you're, our test is the test that this court applied in Morse versus Frederick, which is if you are under the school's supervision or sanction, the school has the authority that the school speech cases give it. And if you're outside of the school's supervision or sanction, then the same First Amendment rights apply to you as apply to everybody else.
Well,
the internet doesn't change that, Your Honor. I mean, the internet, if anything, the internet underscores the importance of assuring that kids outside of school have the right to speak freely, because that's where kids speak. They speak to their friends. They share their most intimate thoughts on the internet with their friends. If any time they do that, and that means that somebody in school at some point might read it, the school can therefore regulate it if it's if it's a swear word, or if it's disruptive, or if people object to it in school in a way that causes problems for the school, then kids won't have free speech. Period. They will essentially be carrying the schoolhouse with them wherever they go. It would essentially reverse Tinker.
Yeah, I think he's right.
You say in your brief a fairly obviously strong defense of the First Amendment, but then you say that the First Amendment rights adjusted for youth and context. And at that point, I suddenly think, well, we're just back in the sort of multiplicity of factors, and nobody can tell quite exactly where any clear lines are. What do you mean by adjusted for youth and context?
So this court has said that unprotected categories of speech can be adjusted for youth and context. It said it in the context of threats. It said it in the context of obscenity. So, for example, what is threatening to a 5-year-old is different from what's threatening to an adult. What is harassing to a 12-year-old girl is going to be different from what's harassing to a 25-year-old. So those kinds of adjustments, I think the law already recognizes those sorts of adjustments. Our point is you don't need the blunt instrument of Tinker to deal with the problems of off-campus behavior that might have an effect in school, because the First Amendment doesn't stand in the way. It permits regulation of threats. It permits regulation of bullying, harassment, cheating, as long as those are carefully confined by the existing First Amendment doctrine.
You said the blunt instrument of Tinker. I'm not sure it's so blunt. I mean, we've had trouble so far, I think, in figuring out exactly how it applies in the present situation. But just so I understand, no matter how disruptive a particular speech activity off campus, or I gather, on a Snapchat is to the school, it has no choice but to tolerate that because it can't take any action against the student.
Your Honor, it can't take action based on Tinker. It can take action if the First Amendment permits it to take action. So if it is harassing, it is severe and pervasive in a way that interferes with equal access to education, they can take action consistent with the First Amendment. If it is bullying that is severe or pervasive enough to interfere with access to education, they can take action consistent with the First Amendment. If it is aiding or abetting cheating, they can take action consistent with the First Amendment. The simple rule is when you're inside the school when you are under the school's supervision, the school has broad authority based on disruption alone. But outside of the school's supervision, the First Amendment governs, and the school has the same authority that the city would have with respect to regulating speech that is not under its supervision. But that doesn't mean it can't take action. It just means it has to do so consistently with the First Amendment, rather than what I would say is a blunt instrument. Just call it disruption, and that's the end of the matter.
Thank you, counsel. Justice Thomas.
Yeah, I love it. Yeah. Inside school, Tinker.
Yeah.
Outside school, normal First Amendment world.
Yeah.
The First Amendment we all know. The First Amendment we all know / love.
And the good thing about his test is it's simple.
It's
We're already
simple.
living under it, but
that's right.
It's a jurisdictional argument, though. That's essentially what he's doing. He's laying out the jurisdictional argument and just kept it simple. Inside school, Tinker. Outside school, First Amendment.
Yeah.
Yeah, and then he's pointing out that the school could act kind of as the government could if it were outside school, like if it's harassing or bullying or cheating or something. Like, so presumably the town could do it, the city attorney could do it, the DA could do it, police could do it, so the school can do it kind of on the same sort of, they're the same sort of posture.
It's another government authority, right?
Right. It's just another government authority, and they can deal with it in their domain, as the entities I just mentioned can deal with it in their domains.
Yeah. And I think too that the government's concerned that there's this blurred lines between online and in school. I mean, if they're concerned that students are going to be looking at that Snapchat while in school, they have already a way to regulate that, and that is by not allowing cell phones at school in classrooms, which is, right, I'm pretty sure, something that they already do. So, but
this argument that they have now about custodial and non-custodial, because they were when the school has custody of the children, then obviously they're going to have a little bit more authority to, regulate speech and regulate that. But when they don't have the custody, then you're talking about just like any other place. And it makes sense if you think about it being in prison, for instance. When you're in the custody of the government, they have more rights over you than if you're not in custody, then with your First Amendment rights would just apply. So I like this. It's very simple and it's very, boom, boom, boom. We're living under this now. It's just now saying it to make it law.
Yeah. Now let's see them, try to poke some holes in it, see if it stands.
So far, he's doing good. He's got a nice, simple test. He's applying it very consistently. He hasn't run any problems yet. Let's see if he can hold the fort.
Yes.
Let's see if he can hold it down, baby.
Thank you, Mr. Chief Justice. Mr. Cole, you a number of times have said, you've mentioned that the location of the conduct or the speech at school, under the school supervision, etc. Isn't that complicated by the internet and by social media? And you could send the exact same messages that could cause problems from your local 7-Eleven, or you could send two classmates who happen to be in class. You could send it over the weekend, but it still has a permanence that would certainly allow it to be used in class. So I don't know how you locate the conduct in school versus out of school when you have social media.
Thank you, Justice Thomas. I think you do it the way this court has done it in all the school speech cases. It said, does the school exercise supervision over the speaker? If it does, it can regulate it subject to enhanced power. If it doesn't, it can't. So Bong Hits for Jesus could be regulated because it was in a school-supervised event. But if it was put on Facebook, it couldn't be punished.
So does the speech occur when, and I'm sorry to interrupt you, but does it occur when it's written or posted or when it's read or downloaded?
It occurs when it's when the speaker acts. And of course, schools are perfectly permitted to ban cell phones, etc. in school. And indeed, Mahanoy High School does precisely that. So the question is the speaker under the supervision of the school? And if the speaker's under the supervision of the school, you can stop him from swearing. If the speaker's under the supervision of the school, you can stop them from publishing an article about teen pregnancy. But if the speaker is at home on the weekend, you can't stop her from publishing an article about teen pregnancy, and you can't.
This is alluding to school newspaper cases, and in these cases, the school was running the newspaper, and this is completely right. The school can do this. So if they want to prevent them from writing about the teen pregnancy in the school paper or the school yearbook, that's okay. But if in the local paper, not so much. Even if this is a school where everyone reads the local paper, because that's what kids do these days.
And this goes back with the original test. Inside the school, tinker. Outside the school, First Amendment.
Yeah, I love it. This guy has my heart.
This is 9-0.
I'm ready to write an opinion, Alita.
Can't stop her from swearing. Her parents could, and it's her parents' job to regulate, not the school's job at that location.
So if the speaker sends an email that is opened, sends the email over the weekend, but it's opened on Monday morning in math class, as far as you're concerned, the speaker is not under the supervision of the school.
Right, the speaker was not when the speaker spoke is the relevant question. And again,
so let me go to another area just briefly. Is there any difference between the regulation of athletes or participants and after-school programs, as Justice Sotomayor pointed out? Is there any difference between that organization, after-school organization or activity regulating a student's conduct versus the school regulating the overall student body population?
So I think with respect to whether Tinker should apply, no. That is, Tinker should apply in school-supervised and sanctioned settings, which would include at practice or at a game, etc., on the bus to the game, and not when a person is sitting at a convenience store on the weekend out of season. But I do think there's a separate question, Justice Thomas, which is independent of Tinker, and the Court of Appeals addressed this as a separate question. After it decided Tinker doesn't apply, it didn't end. the decision, it went on and had a full separate section on whether the school can impose conditions on voluntary participation in the activity and whether she violated those conditions. And it looked at that question, which is a separate question, and it found that she didn't violate any of the conditions that were imposed upon her. And that was the end of the matter. And
it was so great too because of the way the school wrote the waiver. It didn't cover what she did. It was such a nice little burn by the Court of Appeals when they read this thing, and like the exact wording doesn't cover the situation. Sucks to be you, school. It was such a very satisfying moment.
But hold on. Isn't that a factual consideration now? Shouldn't that have been done at the trial court level, right?
Maybe it was done at the trial court level, and the Court of Appeals was merely affirming what the trial court said. I don't remember that specific detail. Either way, it was very satisfying.
Oh, no, I could be wrong though. I could be wrong with that. I'm just.
I mean, they did uphold the Court of Appeals. They did uphold the district court. So let's say the district court said it first.
Petitioners did not seek appeal in this court of that part of the question. So I do think there's a serious question of what sorts of conditions can a team impose on voluntary participation in that activity?
See, this is how we take care of you, Nate. This is how we take care of your concern, right? We don't have to deal with the voluntary waiver issue today. We can push that all aside because it's not before us, and we can. Just
it wasn't even on appeal.
We can ignore the question.
It's not even on appeal.
And just be like, in the absence of this is the rule that applies, and we'll deal with the waiver question another day. Please don't ever ask us again. Yeah.
But that question is not posed here because it's not part of the question presented, and it's not part of the question presented because they lost on that below. The court found she didn't violate any of the rules that she agreed to follow, and they didn't appeal on that matter.
So let me ask you one last question. You mentioned that disruption, I think that's your term, the term that we've been using, can be regulated. Would you allow under your formulation a school to take preemptive steps to prevent disruption, or does a school have to await disruption before it can respond?
Oh, no, absolutely. It can respond to predictions of disruption, reasonable predictions of disruption. That's what the court said in Tinker. You don't have to wait for the disruption, but there does have to be a reasonable prediction of disruption. And as to whether...
What's a reasonable prediction?
Well, what the courts have done is they've looked at evidence of whether or not the speech itself might lead people to be offended in a disruptive fashion. And so if in the past people have been offended in a disruptive fashion, you can now silence the speaker.
Thank you.
Justice Breyer?
Thank you. The difficulty I have, I've already mentioned. A few years ago, a superintendent of schools, I think in San Francisco, said, schools have changed a lot, the public schools, since when I went there. He said, today we don't just teach classical subjects. We're there to help the child have adequate health, in many cases to see that he's adequately fed. In quite a few cases, we become a caretaker, and we don't want to send them home immediately because there's nobody home. And we have to plan after-school activities. There are dozens of areas that didn't used to be thought of as within the purview of the public school. Today, in many places, they are. Now add to that the internet, and the internet not just listening to teachers, but also doing homework, and also writing papers, sometimes vaguely defined, and sometimes. How do I get a standard out of that? I'm frightened to death of writing a standard. And Tinker, after all, doesn't really write a standard. It just says you can't regulate school unless it substantially disrupts or hurts somebody else. It doesn't say, if it does, that you can do anything you want. You still must use some kind of test like proportionality or something else. And I can mention that often outside of school, it's the parents' job, not the teachers', if, by the way, there are parents in the house, etc. And I can mention the differences and say, take those into account. But I do not see how to go beyond that, and any suggestions you have will be welcome.
Sure, Justice Breyer. I think it's important that there be clear lines. That's why the Third Circuit issued the decision it did, to make sure that there were clear lines. within the context of school supervision, whether it's an after-school program, whether it's a class trip, whether it's in the classroom, tinker applies. And tinker does mean that the school can shut down a speaker if those words are going to lead to disruption, period. Whether it's political, whether it's religious, that's the state of the law in the cases below. I don't know where the other side gets this exception for political or religious speech. It just doesn't exist based on the case law. But outside of school, the priority is not to give the school discretion to regulate kids' speech. It's to protect people's freedom of speech outside of school. So our line is I think, quite simple. In school, you can apply tinker. Out of school, you can't. What does that mean? It means you can't punish out-of-school speech because listeners in school might be disrupted by the message. It means you can regulate threats, bullying, harassment, and cheating. But it says that when you're doing that for out-of-school conduct, you follow the same rules that everybody else follows, with some, adjustment for the fact that it's kids that are involved. But what we have then is a tailored approach which deals with the specific problems at issue, rather than a sledgehammer approach, which says we're not going to try to define bullying or harassment or cheating or threats. We're just going to say if the school can call it disruption, they can punish it, even if it occurs on the weekend. I think that's a very, very dangerous proposition in terms of young people's free speech, and the court should be very clear, as the Third Circuit was.
Yeah. This guy's totally killing it. Right
I love it. He's staying right on point, and he's solving the problem that the other people aren't able to even solve under their own terms. It's not merely that the tests are complex on the other side. It's that they don't even know how to apply them themselves, which is always a problem. And then this was even more evident with the schools test, because they were floundering around trying to apply their own test. And the U.S. government wasn't much better trying to solve it. And this guy is clean. Yeah. It's like in school, school events, school bus, school supervision.
Yeah, I mean, because the thing I'm thinking about it from every angle, including online learning, right? Kids are at home, but they're in school at home. In that context, you're under the supervision of a teacher when you're in class online. So that would count as speech that's not protected. That's school speech, right?
Well, that might be another interesting thing in that particular context, because now you're also simultaneously in the home and potentially also simultaneously in your parents' supervision. And we've actually seen some things that have been tangentially related to that, because there have been an example where, like, what was it? Like, there was a picture of a gun, or maybe there was an actual gun on the wall or something, and school tried to regulate that, like bringing an arm to a gun or something like that, where you've seen schools trying to regulate inside into the home. Because it relates to school stuff too, so there is some tension there too.
Yeah,
because that's another problem for another day too.
Yeah, right. But I think this test would work in that situation though, because I mean, I would be okay with that. I would be okay with the court saying, the school can regulate a student's behavior, a student's speech when they're in a digital classroom, because that is going to disrupt the educational experience for all of the other kids that are already having a hard time as well.
Works for me. I'm sold. I'm sold, because it does keep the lines clean enough, at least for today's exercise. I don't need to deal with that problem. So yeah, I'm sold.
Yeah.
Thank you very much.
Justice Alito?
Mr. Cole, there is a huge gap between the broad and very important free speech issues that have been briefed and discussed this morning and the particular incident involved in this case. If we're going to address the broad issues, then I, for one, think we need clear rules that protect freedom of speech. On the other hand, if the court, having decided to take this case, wants to decide it without addressing those broad issues, of course the court could dismiss the case.
Ooh.
And I assume you wouldn't have an objection to that. But if the court doesn't do that, could the court do something along these lines? Say, tinker applies in the school. It says nothing one way or the other about what a school may or may not do to student speech outside the school. we look at the particular comments made here. They're made in colorful language, but substantively, they boil down to something like, I have no respect for the school, I have no respect for the cheer squad, I hate the school, I hate the cheer squad, I also hate my private softball team. A school can't discipline a student for off-campus speech that does no more than say, I hate the school, I have no respect for the school.
So, we're satisfied, Justice Alito, with a ruling in our favor. Whether you dismiss as improvidently granted.
If they dismiss this as improvidently granted, I'm going to feel very unsatisfied.
Yeah.
I'm just saying. I'm going to feel like a man who's been brought to the edge and then left alone. I'm going to be very, very unhappy camper.
Just hanging on a cliff.
Yeah, it's like this is a huge free speech case. And if they wind up, I was like, well, we shouldn't have heard this case. I'm going to be a very sad panda. They got to hear this case. They got to give a strong free speech message. They got to really stick it to the school.
Yeah.
And they can write a treatise while they're at it, as far as I'm concerned, I'll help.
You say, under no conceivable circumstance, under no conceivable test, is this speech proper to punish. But that, of course, is not the question that the court took. And if you're going to address the question that the court took, which is, should Tinker and its broad-based, free-floating, substantial disruption standard, which has no safe harbor, as the government puts it, for political speech or religious speech, should that be applied to kids not only when they're under the school's supervision and they're captive and they're more vulnerable, but should it apply to kids on the weekend, in the middle of summer, when they're talking to their friends on Snapchat? In essence, should the speech rights of young people be constrained throughout their lives as much as it is constrained in school? Schools are areas of strict discipline. They should be, they have to be. But kids shouldn't have to carry that discipline out with them when they're hanging out with their friends on the weekend. And that's the approach that both the petitioner and the Solicitor General would put forth. We're asking for a clear line, as the Third Circuit said, that furthers the really, I think, critically important interest outside of the school context, that we protect free speech, give kids the breathing space they need to be able to talk candidly and honestly, to share their emotions, to share their feelings, even about school, without fear that some administrator is going to say, oh, well, that was disruptive, or that's going to lead somebody else in school to be upset, and so we're going to punish you.
You mentioned bullying, and I'm concerned about comments that do touch on important issues but relate directly to a student. So is there anything that a school can do about that? You say, I guess, that the school has no more authority in this area than other government officials. So what can other government officials do about that without violating the First Amendment?
So there are bullying codes throughout the country. They're generally limited to the school environment, just as sexual harassment is generally limited to the employment and educational context. So it may be a context-specific concept, but I think what schools can do is they can punish those who bully in ways that violate a constitutional prohibition on bullying. And we think a prohibition on bullying that mirrors the prohibition on harassment by being limited to severe or pervasive interpersonal aggression that interferes with access to education could well satisfy the First Amendment. This court hasn't addressed that yet. But what the petitioner's approach would do and what the Solicitor General's approach would do is say, we don't even have to address the question of how you define bullying, because we'll just call it disruption.
That feels like such a nice burn. I don't know why that line resonates with me so well in particular, but there's something about that that's just very satisfying. We don't even have to define bullying because we can just call it disruption. We can just call everything disruption.
Yeah.
It's like giving this government a super governmental power. I mean, that's sort of the implication of the schools argument and the Solicitor General for the United States argument, is this schools power applies all the places. It's extraterritorial, anywhere in the world, at all times, in all contexts, and we don't even have to worry about the problems that the legislature deal with, things like trying to define revenge porn in ways that satisfy First Amendment tests, which is a whole nightmare. Trying to deal with bullying that satisfies First Amendment context, whole nightmare. Tries to deal with sexual harassment in ways that deals with the First Amendment, whole nightmare. We don't have to deal with any of that thing because we can just call it all disruption. Yeah. It's magic. And suddenly schools become the most powerful government authority known to man.
Which, I mean, generally speaking, in these kinds of cases, when the government tries to draw that kind of a broad definition, that's usually not going to be terribly successful.
Did that resonate, do as much for you as it did for me? We don't have to define bullying because we'll just call it disruption. It's pretty good.
Yeah.
Right.
Yeah, that was a very strong point there.
Yeah. Just put that right in my opinion as I'm writing it, too.
You're already writing it.
School can regulate
I'm writing
wherever it happens. And that makes no distinction between what's mean and what is bullying. And there are important distinctions to be made there, and I think the First Amendment requires them.
Justice Sotomayor? Mr. Cole, the problem with your line drawing is we have traditional categories: fighting words, obscenity, truth threats. We even have definitions of what constitute sexual harassment. The level at which speech has to arrive to meet those standards is very, very high. And I'm dubious that most of the conduct that teenagers engage in would fit any of our traditional categories. So let's talk about harassment, okay? Common episode, I think I read it in the newspaper. A young girl is subjected to, each time she goes out of the house, whether she's in the playground, not the school playground, or walking to school, with a group of classmates walking by and saying, "You're so ugly. Why are you even alive?" That's not a true threat. They're not threatening her with any bodily harm. It is not harassment if they're just speaking. So, and they're not interfering with her movement to or from school. Why that would be the kind of situation that I don't see a First Amendment category fitting. So under your theory of this case, would the school be powerless?
Absolutely not. The school would be permitted to regulate that conduct if it satisfies a First Amendment a permissible definition of bullying. And we think a First Amendment permissible definition of bullying
is what?
Severe or pervasive interpersonal aggression.
What's aggressive about that?
Access to education, which is in fact.
Counsel, please stop. What's aggressive about it? It's basically walking by someone and saying, "You're ugly. Why are you around?" There's a lot of conduct that comes to the edge. You're now asking schools to determine what is constitutional in terms of misbehavior by students that they can attempt to control or not control?
The one thing that sort of strikes me as they're raising this question is this problem, as they're framing it, is not because it doesn't involve the internet at all. Like this would presumably be as much a problem in 1970 as it is today. With students harassing students as they're walking to school and calling them ugly and why do you exist. So my question would be like, we didn't need to deal with, the schools didn't need to deal with that in 1970. So why do they need to deal with it today? What's fundamentally different? Am I missing something here?
I mean, what I'm still trying to think about is, that just sounds like harassment anyway, right? That sounds like
it's certainly pervasive. It's certainly ongoing, and certainly, there's something there there might be a way to write that in a way that would be First Amendmentally permissible.
Yeah. I mean, I don't really see Sotomayor's huge issue here with those kinds of statements.
Yeah, they called it severe or pervasive, which, if memory serves, is also the same test for sexual harassment in the workplace. It needs to be severe or pervasive. If it's sufficiently severe, then one incident might be enough. If it's not sufficiently severe, if it's pervasive enough, it might be. This is the way that sexual harassment in the workplace is written, is meant to distinguish a person. It's not meant to prohibit one person from making a sexual advance to another colleague, on like a one-time basis. It's meant to prohibit, this ongoing thing where it's interfering with the workplace on an ongoing thing. So it's not meant to. And the same thing would be at the school. So if it's sufficiently severe or sufficiently pervasive, it might be enough. And maybe that's okay.
And those kinds of cases also are context specific anyway. So, I mean, you could put a case like that and say, well, in the context of a 14-year-old in high school, it may not be something that is quite as pervasive as it would be for an adult, but for a 14-year-old in this case, in this kind of context, that would be. So I think
that's right.
Yeah.
Yeah, so. It was the guy above, Cole, who was making this. I think the attorney for the U.S. government who was saying this, where he was trying to say that the analysis is modified for kids at younger age. It wouldn't be quite the way I would frame it. It's not exactly the test is modified. It's just that it comes out differently because the facts are different, because the psychological disposition of the people involved is differently. So it's modified in that respect. But yeah, I think whether or not it's the school itself that would have a definition of bullying along these lines, they might be able to write it in such a way that would satisfy First Amendment scrutiny. Maybe that's enough.
Yeah.
So yeah. Where was I? Let's go back here.
Your Honor, within the school context, all they have to find is that it's disruptive. You could be one student could be being mean to or teasing a student next to them, and the school can come in because it's disruptive. Period. End of story. And that's the way.
But you're saying they can't do it if that's happening outside the school.
That's right. That's right. Because outside of the school, the school doesn't exercise supervisory authority. The parents do. Outside of the school, the child has the protection of its parents. Inside the school, it doesn't. Inside the school, the child is captive. Outside the school, it's not. And so that doesn't mean you can't deal with bullying.
All right,
harassment.
counsel, you said to me that there could be conditions to being a member of a team, correct?
Yes.
Could one of those conditions be that you won't post foul language on social media?
I think the question would be whether that's necessary or even reasonable in terms of the purposes of the team. So if it were, yes.
This school code, it doesn't go far enough away, but it says we want the highest, must earn the right to represent the school by conducting themselves in such a way that the image of the school district would not be tarnished in any way. Our cheerleaders or team members using foul language on social media or at any school function would be a tarnishment. You won't do it, or you'll be punished. Is that a contract that's enforceable?
So I think that is that's a question that's outside of the scope of the question presented, because they did not petition from the determination that she didn't in fact violate those rules.
I like that answer here. Normally I would take a bit of an exception to the attorney avoiding the justice's question, but I think it's proper here because this was specifically an issue in this case that's specifically not in this domain anymore. So I think it's proper to say that's outside the scope of the question.
Right.
So I don't mind that here.
Yeah.
For whatever it's worth.
Spoke out of season. She did not speak at an event. But yes, I think teams have quite a bit of leeway in terms of imposing conditions on players as long as they're set out in advance and the players agree to abide by them and they're reasonably tied to the needs of team unity.
So why isn't, I know that what the court found below, but one of the things that it says here the negative information rule or the cheerleading rules provided, there will be no toleration of any negative information regarding cheerleading, cheerleaders, or coaches placed on the internet. Why isn't what your client did a clear violation of that part of the code?
The Court of Appeals found that there was no information whatsoever in what she presented. And again, the petitioners did not appeal that determination.
Justice Kagan?
Mr. Cole, you're making Tinker basically a geographic test. And it's possible to read it that way, but it's also possible to understand Tinker as a decision about what's necessary for a school's learning environment. And it might be that student speech that occurs outside of school is sometimes going to cause fundamental problems, disruption of the school's learning environment. And I guess then the question is why we shouldn't acknowledge that and allow a school to deal with it.
So, Justice Kagan, our test is not a geographic test. It's a supervision test. It's the test that this court has applied in all the school speech cases. And I think there's two reasons. The first is Tinker is an exception to the bedrock principle that you can't punish a speaker because the listeners objected, even if they object disruptively. If you take away the line between what happens under school supervision and what happens outside, you have turned the exception into the rule for 50 million public high school students. The second reason is that this court's school speech cases are contrary to that notion. The article about teen pregnancy that this court said in Hazelwood could be censored because it was in a school-supervised newspaper. If the student went home and published the same teen pregnancy article on her own private blog, it would have the same concerns, the same effect. The concerns were about privacy of other students, and yet the school couldn't regulate it. Swearing, or bong hits for Jesus. The bong hits for Jesus sign, in terms of promoting drug use, would have the same effect if it was put out of the kid's bedroom window while the students walked by on their way to school, or put on his Facebook page. And yet,
Mr. Cole,
very clear, you can't.
I mean, those are some easy cases, but you've also been asked about bullying cases, harassment cases, and you've tended.
Alita, you looked like you wanted to say something there, and I didn't want to interrupt your flow. What do you got?
No, I just, it was perfectly consistent. I mean, this is a great argument tactic, is to say, this is exactly what the Supreme Court has been doing this entire time. You just didn't know it. I'm just putting a different name on it. And so this is completely consistent. It's very smooth.
It's very satisfying. And the other tests are in no way satisfying. Yeah. It's smooth, clean. I love it. It's great.
It's 9-0, baby. It's 9-0. Hey, Kurt,
one can only hope. One can only hope.
I'm gonna be out of here in 3 minutes because I got to run in the morning.
Okay, well, you're lame, but that's all right. Being a leader will hold down with the non-lame people. Maybe you can fix your camera.
To say, well, sure, don't worry, you can deal with that because there may be constitutional codes that are anti-bullying or anti-harassment, and there may indeed, but I think we have a general sense that schools have more latitude over this kind of speech than other government officials. So I'll just give you one example. Suppose that there are boys in a school who have a website and rank all the girls in the school on matters of appearance and such things, or maybe talk about their sexual activities. And we wouldn't put people in jail for that, outside of a school context. But it seems as though a school should be able to deal with it. Why not?
I think a school should be able to deal with it. And I think that's what the bullying laws actually reflect, that intuition. There's no prohibition on bullying generally between adults.
Well, let's say that this, I'm just stipulating that there are some categories of speech that we could not punish outside the school context, and ask you if you can't imagine cases where even though we couldn't punish it outside the school context, and I think mine is a good example. You can't put people in jail for commenting on other people's appearance. But shouldn't a school be able to deal with it?
So yes, a school should be able to deal with it, but the way to do that is with a test that addresses that particular problem. As Justice Alito's opinion in the Sachs case for the Third Circuit said, the mere fact that you call it harassment doesn't mean the First Amendment goes away. You still have to assess, is it narrowly tailored or does it punish too much speech? And that question could well be affected by the school environment, could well be affected by the fact that kids are involved, but you should ask that question and decide that question with respect to a particular problem like bullying or harassment, rather than adopt a broad brush, free-floating disruption standard that, yes, it might reach that, but it also reaches political speech, it reaches controversial speech.
Well, what do you think about the SG's test, which basically says, when there is a distinction between in school and out of school, and we can't punish anybody for wearing a Confederate T-shirt outside of school, but once the outside of school speech is really about the school and affects the operations of the school, then it is subject to tinker again.
I think the SG's test is the vaguest test that's been put before you. It would require schools to distinguish between speech that is spoken to a student as opposed to speech that is targeted at a student, speech that is about a program as opposed to speech that is targeted at the program. It would allow schools to define in an unreviewable fashion what is essential to any school program. So suppose the
Thank you, Mr. Cole. Thank you.
I love that answer.
Justice Gorsuch?
Mm-hmm.
Yeah, I'd like to follow up with where you left off with Justice Kagan. I'm struggling to understand the delta or difference between your test and the petitioners at the end of the day with respect to off-campus speech that results in a person on campus being denied an educational opportunity, which is what I understood your test for off-campus bullying to be. What is the difference between that and a substantial disruption on campus test?
I think there's really two basic differences, Justice Gorsuch. The first is that their test is disruption, covers anything that anybody says off campus that might have an effect on campus. Let me just pause there. I'm sorry to interrupt, but let me just pause there and say, rather than substantial disruption, you would say it has to disrupt an individual's educational opportunity. I'm just not sure what that difference is. Right. So no. Maybe I misstated. Our position is that bullying can be regulated like harassment, consistent with the First Amendment, where it is defined as interpersonal aggression so severe or pervasive as to interfere with access to education. All of that is critical to that definition. It's not just had an effect on the school, whereas their test is just had an effect on a school, and therefore their test would encompass someone who puts up a sign that says Blue Lives Matter More, or somebody who criticizes the coach for physically abusing players.
That one is not a hypothetical. That actually happened, where the school disciplined someone for criticizing the coach for physically abusing players. And I'm trying to remember how it came out. I think at one point the school said that they could do this. I forget how it came out on appeal if they said the school could do that, but that actually happened. Do you remember how that case, Alita, came out? Off the top of your head?
No, I don't.
Yeah, but that's a thing that actually happened. The school actually disciplined students for saying a particular teacher was bad because of physical abuse. Yeah, so that's the thing that happened.
Or somebody who organizes an off-campus protest of the school's COVID policies. All of those things could be disruptive, but they wouldn't be bullying, they wouldn't be harassment, they wouldn't be threats, and under our rule, they would be protected.
Why wouldn't they be bullying? Under your definition, severe interpersonal, I'm sorry, I missed the rest of it, but it strikes me as, you could easily take a lot of those examples and put them in that bucket.
I don't think so, Justice Gorsuch. Putting up a sign that says Blue Lives Matter More is not bullying under any reasonable definition, nor is whistleblowing about a coach's physical abuse or calling for a protest of a school's COVID policies. But all of those things could be disruptive in the school. And under their test, they could therefore punish the speaker for expressing those those messages. The other difference between our test and their test is that our test would require careful definitions of bullying, harassment, and the like, rather than just waving your hands, calling it disruption, and going away. And the problem with that is then you're not distinguishing between, ordinary mean comments or teasing and bullying and harassment. And this court in Davis and Justice Alito in the Sachs decision said you have to make those distinctions if you're going to be consistent with the First Amendment.
But you would agree, if I understand it, though, that there could be some school-specific First Amendment regulations, right? I mean, as Justice Kagan pointed out. Yeah, all right. And then let me ask you, just to turn to another topic and back to the facts of this case. Why doesn't it make a difference that the speech here was addressed in the context of an extracurricular activity, and that the standards there may be different from, higher than, what may be required of all students in the school environment?
So I think it can make a difference, Justice Gorsuch. It doesn't make a difference to the question presented, which is simply whether Tinker applies out.
No, I understand that. I'm moving now from the general to the specific, if we're going to go down the road of writing a narrow opinion.
Right. So to the specific, I think there are serious questions about sort of what sorts of, because extracurriculars are voluntary, schools can require students to agree to certain kinds of conditions on participation in the program, as long as they're set out in advance and consistent with the First Amendment. And so, for example, I think a school could say, if you're going to play on our team, you can't personally demean other players. And if they set that out in advance and the student agrees to it, and then the student does it, they can punish the student. If they don't set that out in advance and the student says something demeaning, they can bring the student in and say, hey, that's not acceptable. The condition for playing on this team is that you don't demean others.
So that the only,
and then there's an advance rule. If they do it again,
the outcome of this case hinges on whether there was a policy in advance.
Well, it does if the justification for the regulation is voluntary participation and agreement by the person to a certain set of conditions that would otherwise not be permissible. But again, that is a separate issue. The Third Circuit addressed that issue after it decided Tinker didn't apply. It didn't say the case is over. It said there's a second issue. It may be, even if Tinker doesn't apply, that if she violated rules that she agreed to, that's a permissible basis for her expulsion from the team. And then they looked at it and they found she didn't actually violate any of those rules. And again, petitioners did not appeal on that question.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Cole.
Good morning.
I obviously think it's unfortunate this spiraled, this case, the way it did, and completely understand the young woman's reaction to being upset with the decision. As I mentioned to Ms. Blatt, I think that's entirely typical and widespread for decades and decades when kids are disappointed by something like that. And then the coach's reaction, it seems like an excessive sanction, but we're not there. We don't know all the circumstances and don't want to second guess that too much. But I guess I'll start where Justice Gorsuch was discussing with you. It just seems entirely different to be talking about a team and not a school, and I'm just not sure, and I'm going to ask follow-up questions about this. I'm really trying to figure out the practical difference for courts in the wake of this case between if we adopt your test and Ms. Blatt's test. So team, and then move on to that if you can.
So our test is the Tinker disruption standard applies within the school supervised settings, not outside. So with respect to teams, if you're on the field, if you're at practice, if you're at the game, if you're on the way to the game, if you're, then you are subject to Tinker and disruption applies. If you're at a convenience store on the weekend, Tinker does not apply.
So suppose keep going.
End of story. And the fact that you're on a team doesn't change that question, because there's nothing about your involvement in a team that affects the Tinker analysis. But there is, I think, a separate and independent question, which is what sorts of conditions can a school impose on a person if they join, say, the football team or the pottery club. And those conditions might be different. And they were there, and I think reasonable conditions are going to be permissible. And here they set forth some conditions. She agreed to abide by those conditions, and she didn't violate any of those conditions. This happened out of season. She did not do anything, while she was in her cheerleader uniform. She did not post any negative information on the internet. She basically expressed her frustration, as I'm sure you did, when you had disappointing games, and as I did when I had disappointing races, and that didn't violate any of the rules.
Or maybe with respect to Kavanaugh, not so much with the disappointing games as maybe disappointing congressional hearings. Sorry, couldn't avoid that one.
But I this question about the waiver, though, I mean, it does worry me a little bit, because I would think that if the court is going to talk at all about whether or not schools can have kids, waive away certain contractual or certain constitutional rights, even that has to have some sort of like guardrails, right? Because like this guy is saying, she did it out of season. It was off campus. It was out of, how far can that waiver go? Does it have to say only during the school season, only when you're at events, or can it reach to 24/7 during the school year, or I mean out of the during the summertime when they have summer camp, or
I mean, there are some schools with non-traditional school years. There's some schools with year-round schooling, so there's that too.
That's true. That's also true.
So I mean, that's definitely a question we don't need to answer for today. I think we both agree that they can put some conditions on here.
Yeah.
I think we could probably even go further than that. I think the government can probably, even to adults, put some conditions on some circumstances without us necessarily having to figure out what those circumstances are. But they might need, you probably can require even adults to waive constitutional rights in some context that we don't need to specify. Of course, some doesn't imply all.
Right.
And we don't need to necessarily figure out what those limits are today. They're probably a little bit further than they are for adults and the general public because of the environment, but we don't need to solve that question. If we really wanted to write something about it in our opinion that we're writing, Lita, which we're going to somehow just slip in there and pretend that no one notices that it's written by us. We'll just say that that they can put conditions on participation that are consistent with the First Amendment, but can't put unconstitutional conditions that are unduly coercive of the First Amendment interest, and we can leave it to the courts of appeal to figure out exactly what that means, because that's what courts of appeal are for.
True.
And that's the end of the matter, because they have not sought any review of that. So in a separate case, you might take up the question, what sorts of rules are reasonable to impose on involvement in a team? What I will say is that if you look...
Sorry to interrupt. Suppose in this case, the Snapchat had been a racial epithet about the coach.
A racial epithet about the coach? I think if they have a rule that says you can't demean other players or the coach, you can't engage in insubordinate speech to the coach or about the coach, then they could punish her. If they don't have a rule, they could bring her in. They could say that is totally unacceptable.
But they can't punish her for racial epithets. I guess this goes to Justice Gorsuch's question as well. Unless they have a clear enough policy in advance, you can't punish a student who uses racial epithets in a Snapchat about the coach or other players, in your view?
I think here's what you can do. I think you can bring that person in and you can say, that is unacceptable. If you have not set that condition out in advance, you then set it out. And then if they ever do it again, they're off the team. So you can definitely deal with it in a way that maintains the authority of the coach and the unity of the team. But if the justification for additional requirements on team involvement is that you have chosen to join the team and therefore you can be asked to sacrifice some of your First Amendment rights in advance, well, then you have to be told what you're sacrificing.
I just want to pick up on Justice Breyer and Justice Alito, because maybe I don't want to be misunderstood on what I'm saying. I think you can answer the question presented here very clearly without writing a treatise. And that's the point I was trying to make. And the question presented is just whether Tinker applies off campus. We could answer that yes or no. If we answer it yes, obviously that will answer the question presented. If we answer it no, here's the point for you. You still have all these exceptions that allow, as I understand it, the First Amendment, that mean that the First Amendment does not categorically prohibit public schools from disciplining students for speech that occurs off campus. So I think that's the point that Justice Gorsuch was making. You just do it differently than Ms. Blatt. She says Tinker applies off campus. You say Tinker doesn't apply off campus, but by the way, the First Amendment still allows the schools to regulate speech that occurs off campus in a number of circumstances. I'm just wondering whether that's worth the candle.
Well, I think it's very much
I'm
worth.
not sure I've ever heard that expression, worth the candle. I guess that's worth the effort or worth the juice. Is the juice worth the squeeze kind of thing?
Yeah,
right?
I guess so. Yeah, I haven't heard that.
Yeah, it must be. But yeah, to me, it's worth the candle, whatever that means, because to say that Tinker applies inside the school and say, okay, so Tinker allows you to regulate speech that is disruptive of the school environment because it occurs within the school's custody.
Right.
That's the idea.
Yeah.
So within the school, you're within the school's custody, whether that's on campus, in a school environment, play, drama, sport, whatever. So that's the rule. Outside of school, then Tinker doesn't apply. So what's the rule now? Well, now the rule is, you can't do disruptive, but maybe you can do some more specific, narrow things, like a specific narrowed bully thing, which we've talked about, a specific narrowed harassment thing. Yeah. That we've talked about. That might be consistent with the First Amendment. So is the juice worth the squeeze? For me, yeah. And I think it's a very big difference for me.
Yeah. Yeah. I think, no, I definitely agree. I mean, it seems like, if it's within the school supervision, you have like this enhanced First Amendment authority or First Amendment rule that only applies in school environments. And then outside of that, it's normal First Amendment rules apply. That makes sense. That makes perfect sense to me.
We're on the same page.
Yeah.
The candle.
Well, if it really creates different results, you're just saying that as long as they write the policies in advance, it'll be.
No, not at all. Not at all. I think, look, there are hundreds of Tinker cases. Virtually all of them involve suspensions for things that kids do vis-a-vis as students. There's about a handful of team cases. So that's a different category. I don't think it's presented by this case for the reasons I've indicated. With respect to the basic question presented, which is, should Tinker apply off campus? The delta between our position and theirs is that ours says, ours protects politically controversial speech. Ours protects whistleblowing. Ours protects venting frustration, on the weekend. And ours does not say that schools can't address off-campus speech. It just says if it's off-campus, you have to address it consistent with the First Amendment rules that govern that particular problem.
Justice Barrett? Mr. Cole, I want to pick up where Justice Kavanaugh left off. I want to make sure I understand your approach. Let's talk about the harassment example that you were discussing with Justice Sotomayor. Tinker doesn't apply off campus. Let's say, that we're in that world. And you say that the school could, much like a city official, if I'm understanding this correctly, prohibit harassment that rises to the level of interference with another student's educational opportunities. And I assume that would be judged if the school adopted. Would you envision that in a bullying statute, or would you envision that in a school adopted policy? We'll start with that.
So I think the schools have generally adopted bullying policies. The states have required them to adopt bullying policies, and there are many, many such policies. And our view is those are constitutional.
Okay, so let me ask you about the test. So the policy comes from the school. So the school adopts a policy, say, about bullying, and then it gets challenged when a student is disciplined for off-campus bullying. Let's imagine Justice Sotomayor's example of the, you're so ugly, and it rises to the level where the child just can't go to school anymore. Or the example about the disabled student who was taunted with sexually graphic images on his way home from school. That's subject to a First Amendment challenge, and what you're saying, well, there's a compelling state interest, but it's narrowly tailored. Is that what you're envisioning? It's content discrimination, but...
Yeah, our view is just as the sexual harassment law with respect to hostile work environment is permissible in terms of prohibiting severe or pervasive harassment that interferes with equal access to the employment place, so too a bullying law that prohibits severe or pervasive interpersonal aggression sufficient to interfere with access to education would be constitutional. I think it could be constitutional under Gibney, as this court suggested in RAV with respect to sexual harassment, or it would be narrowly tailored to a compelling state interest. But if you define bullying, as some of the codes do, as anything that would cause emotional harm, without these kinds of guardrails, I think that's not consistent with the First Amendment. And so the court ought to address that in an appropriate case and determine what the appropriate definition of bullying is.
What about cheating?
I love this answer so very, very much because it's respecting the First Amendment doctrine when it comes to strict scrutiny, right? We need a compelling governmental interest and it needs to be narrowly tailored to that interest. So it's like, okay, look, if it's sexual harassment or if it's bullying, severe, pervasive, to such a degree that it interferes with the individual's ability to participate in the educational environment to that individual, that might be enough. Yeah. But not just anything that causes some sort of displeasure or harm or, whatever. That's not enough because it doesn't meet the strict screening test. I love that answer. I love the way he answered that question. It's great.
Yeah.
I wish I was that smart sometimes.
Likewise.
It's the right answer.
How does cheating fare? Justice Kagan's example of the student who goes home and emails out answers to geometry homework.
So Gibney allows for the prohibition of speech integral to prohibited conduct, and that covers aiding and abetting. Aiding or abetting cheating is just not protected at all under Gibney.
Well, I like that answer too because it goes to the idea of just aiding, abetting, or conspiracy law in general. Can you prohibit speech that aids, abets a crime? Yes, you can. So it's when it's that you can punish because that's conspiracy, right? Or that's aiding, abetting. It's like you're there. So, cheating is forbidden, therefore the speech is forbidden. I'm there.
Under normal circumstances, that is something speech that's not protected under the First Amendment. So the same would be true for a student in this situation.
Yeah, and we're calling cheating a quasi crime in this scenario, which works for me, so I'm happy.
But what about? Let's see. If you're thinking about something that's a crime, right? Aiding and abetting is different, but the school can define in-school offenses. So it can define cheating as an offense, but what if it defines, demeaning classmates as an offense?
Well, I think it has to. I think what Gibney is about is speech integral to prohibited conduct.
Right. So and what if the prohibited conduct? But what is to say?
Conduct versus speech.
Wait, I'm sorry. Go ahead.
The difference is conduct versus speech. The rationale of Gibney is if you're regulating conduct, the fact that there's some speech integral to that conduct doesn't make it a First Amendment problem. So if and schools.
So the cheating is your answer is that the cheating is conduct. I mean, the circulation of the answers is conduct.
Cheating is conduct, however it's done, and if you aid or abet cheating through the circulation of answers, yes, it can be prohibited.
Okay. What would be wrong with a test like this? One of your problems is that it's difficult to define the school environment and what constitutes the school environment. What would be wrong with saying that the school environment exists when the student is relating, not just supervisory, I mean, that's narrow. What about when the student is relating to the school in the student's capacity as a student? So if the student is directly communicating with the school, sending emails to the school, sending emails to a teacher at the teacher's school email account, would those be within the school environment on your definition?
Yes, because you would be subjecting yourself to the school's jurisdiction. If you call the school, if you send an email to the school account, you are now subjecting yourself to the jurisdiction. But if you send a text to 6 of your friends who happen to be classmates and you do it on the weekend, you're not subjecting yourself to the school's jurisdiction, and you shouldn't be treated as if you're in school.
Thank you.
A minute to wrap up, Mr. Cole.
Great answer.
Thank you. Everyone agrees off-campus bullying, harassment, and threats, properly defined, can be regulated. The difference between the other side's tests and ours is this. Ours would protect political speech, whistleblowing, and venting frustration outside school, even if a principal predicts it will lead to disruption. Theirs would not. Ours would preserve the rule against content discrimination and the heckler's veto outside school. Theirs would not. Ours would provide breathing room for free speech outside school. Theirs would empower school officials to monitor everything students say to each other anywhere. And ours would require clear definitions of off-campus bullying and harassment consistent with First Amendment principles. Theirs would call it disruption and dispense with further definition. The fact that petitioner claims it can punish BL for a momentary expression of frustration on a weekend out of school and out of season shows how sweeping its approach is. Its rule would teach students they can never speak candidly with their friends without worrying that a school official will deem their views potentially disruptive and suspend them or otherwise punish them. That is exactly the wrong lesson to teach. Thank you.
I mean, not that you'd expect anything less from Supreme Court advocates, but I really loved his introduction, his introduction 2 minutes. I loved his closing 1 minute. It's so great. I loved every piece of his argument. I want to adopt it. It's like all those things. And he's so good at answering the questions. And making sure that he was keeping the nuance. And I was trying to decide at some points if it was that the justices were trying to test him on the nuance or if they were actually losing it. And I think at some points the justices were losing the nuance. Between even things like speech and conduct and stuff like that. And he maintained it. And he was just like on point, solid, consistent, logical.
He was just steering the ship right for them.
Steering the ship is like, it's like, well, you say this. And he's like, yeah, you say, so Tinker doesn't apply. So, but you also say, is it worth the candle? It's like, yeah, because we have this rule and this rule. And then we need something more specific. And here's how you define it. We have examples that would work, that solve your problem. And, just go. All right. So now we get to listen to the conclusion of this. We're almost done with this thing. We get to listen to Ms. Blatt's rebuttal for 3 minutes or whatever it's going to be.
Thank you, counsel. Rebuttal, Ms. Blatt?
Thank you, Mr. Chief Justice. There's some sort of twilight zone going on when the head of the ACLU says that schools allow heckler's veto, punishment for whistleblowing, any kind of reporting, any kind of criticism. All that matters is someone is offended. And you have the Biden administration and the school district saying, that's not true. That's not what Tinker allows. Now, Mr. Cole said the case law allows us to act like Soviets and the North Koreans. But since the Sachs opinion, the Morse concurrence, Fillmore, and Zelenek have left clear lines for schools and that heckler's veto are not allowed. And your choice is this. If you can choose to either tighten Tinker or you can say, well, we're going to assume Tinker's out of control on campus, but we will leave open season on schools and complete chaos as to what their test allows. Under their view, all 50 states define bullying in terms of Tinker. You have the same email chain that would toggle on and off campus, and you would have the Tinker test applying when there's some on-campus speech. And I don't know what applies. I think Mr. Cole said it's the Tinker test, but he's afraid to use the Tinker word because it's scary, and it shouldn't be. You're much better off cleaning this doctrine up. Justice Kagan, you had amazing questions about school speech. Remember, our test is the audience has to be the school. So all of your speech, if it's to the press, the police, your pastor, your family, etc., none of that is school speech, even if it involves the school topic. Justice Barrett, on threats. The facts in Bethlehem in Pennsylvania and Bell, nobody knew whether that was a threat. The police were sort of involved. It is not fair to the parents of those other kids to have schools fumbling around. I don't know what this applies. Before we had Tinker, part of the threats were on campus, part were off. It was on the internet. Let's look at where she drafted it. Maybe she was to and from. Now let's move to the school supervision. Madness, confusion, and chaos. Please don't do this to schools. Mr. Cole said you could prevent swearing to and from school. That's nuts. You're in the dad's minivan? That's school supervision under their view. No one thinks Frazier applies there. And yet, all of a sudden when you get out of the minivan, and I guess walking to it, but maybe it depends on how far you park, Tinker is going in and out of coverage. That rule makes no sense. There's no case law on conduct that aids and abets school speech. You will have a school speech petition. You can keep denying cert, but I guarantee the courts are they're going to freak out when Tinker has been the law off campus for 20 years. Thank you.
I don't
Thank
really
you,
understand
counsel.
what she just said. I don't. She lost me like 2 sentences in. I don't. I mean, she was saying. I mean, so let's start with the comment that they said that we're being like Soviets. She had mentioned gulags earlier. The thing is that kind of rhetoric doesn't work when the other side isn't actually using that as an argument. Mr. Cole, he said nothing that was super dramatic. In fact, he was quite reasoned. So it's just, with her saying like, they're calling us the Soviet Union, we're not North Korea, we're not blah, blah, blah. It just feels like she just went way off the rails. And then, yeah, that was weird. That was a weird ending. She started off pretty well, but that ending was just.
I'm not sure I grant that much, but okay. That she started well. I'm not.
Oh, not the ending. She didn't start well in the ending. I mean, in the beginning.
The
of
ultimate
the
beginning, long ago, in the far away beginning.
Yeah,
maybe. Yeah, that was. Remember how I just said just now when the other guy stopped talking, how that was perfect and great and illustrative and wonderful, and I was watching your face, and I know you're watching my face.
Yeah.
And we're both looking at each other like, what the fuck is this? What the fuck is this? It's like, what is this? What is this absolute train wreck?
Yeah. She lost her
Cole
chill.
says the case law allows us to like Soviets in North Koreans. What?
Yeah, he never said anything like that.
We'll leave open season on schools in complete chaos.
Yeah, the irony of that is that I
They're
felt
afraid to use
like
the
there was
tinker
more-
word because it's scary.
Yeah.
What the fuck is this?
The irony of her point of chaos is that I actually felt that trying to apply her test and trying to apply the government's test would lead to a lot more chaos than what Mr. Cole said on behalf of the cheerleader, because his test is pretty straightforward. It's very simple. So
it was a train wreck, Alina.
Yeah.
It was a total absolute train wreck.
Yeah. Yeah.
I don't know if she had any credibility before this. I mean, I guess, but there is a well kind of established rule that you can't win at the U.S. Supreme Court an oral argument, but you can lose. And this would be kind of what that looks like. You can't win, but you can lose.
Yeah.
And yeah, so this was an absolute train wreck of straw man to absolute death, red herring, appeal to credulity, and I think every other logical fallacy known to man might have been buried in there. And also, when they said, you're going to and from school, they weren't talking about Dad's minivan, unlike what she said.
Right.
She's like, Mr. Cole said you could provide swearing to and from school. That's nuts. You're in Dad's minivan. That's school supervision. That wasn't what they were talking about.
Yeah,
they were talking about on a school bus.
Right.
Not Dad's minivan.
Which is exactly. I mean, that would be supervision by a school. It's pretty clear because you have a coach there. You have you have chaperones ostensibly. But if you're just in your dad's car, dad's minivan on the way to school, no, that is not under school supervision. That is under parental supervision.
You could justifiably rescore your prediction for the outcome of this case just based on that last 3 minutes. It's like if you thought there were any votes for the school here, just went in a big ball of flame.
The only maybe that I see is maybe two going the other way. Maybe Breyer, just because he seemed a little confused by Mr. Cole's test earlier, but I don't know about that. And then maybe Sotomayor, because she seemed to be much more influenced by what's going to cause an effect on the students. So she seemed to want to like that one at least. So I don't know. Those are the two.
You sure you don't want to listen to the last 3 minutes again to see if it makes any more sense the second time?
Oh, I don't know about that. No. It's going to hurt my brain.
No, I wasn't serious because I don't want to do that either.
That was
a lot.
It was a lot of words. It was a lot of words going into my brain.
In the facts case, that's why Pennsylvania, nobody knew whether that was a threat. The police were sort of involved. It's not fair that parents of the other kids have the schools fumbling about around as well. I don't know what we had before. The Tinker part of the threats are on campus or off. It was on the internet. Let's look at what she drafted. And maybe she was. Now let's move to school supervision, madness, confusion, and chaos. Please don't do this to the school. There was a coherent point in there somewhere, I'm sure. I couldn't find it. Well, at least we got you a nice pick me up for the end of the hearing because we were all kind of losing attention. And then Karen over here just went to the end of the page. So yeah, I'm hoping. I'm very, very much hoping for a 9-0 opinion that's going to be like, it's just what the guy for BL said. Tinker applies on campus, look for disruption. Off campus, you need something more specific. Yeah. And how do you know more specific? Well, let's go to strict scrutiny. Why not? Because you're regulating subject matter speech or viewpoint matter speech. So strict scrutiny is your normal test, right? But you have the campus environment, which changes the analysis a little bit. Right. And you have potentially minors, depending on what age bracket you're talking about, which might change the analysis further still. Right. If you're talking about younger ages. So we could have bullying, that would be within this. We could do things that would be here without going to just disruption and incorporating all the things ever. Yeah. So I'm like, okay, I have nothing more meaning to say. Do you have anything more meaning to say before we end this?
That's about it. I'm in love with this test, with Mr. Cole's test. I'm in love with it. I want to marry it. If I wasn't already married.
That's right. I want to marry it too, man. I was like, it's like, yeah, this is pretty good. I'm ready to put a ring on that sucker, man. It's like, it's ready to go. I'm ready. All right. So
I'm just so sad that Nate missed it.
Oh man, no, Nate. I think we got to send Nate the clip of the last 3 minutes with just of our mutual looks of what the fuck is this that's happening right now. It's like all the lawyers in the room are like, what is this? This is not what good advocacy looks like. This is the opposite of that. I've seen some train wrecks. I've seen some train wrecks at the Supreme Court. This might be the worst train wreck I've seen in a long time.
Yeah.
Especially for a conclusion.
Yeah.
I mean, I've seen train wrecks. I don't normally see it this bad. This is pretty bad. Yeah. So we'll just move on. All right. So if you haven't already subscribed to Legal Bites, she just passed 3,000 subscribers.
Woohoo!
It's awesome. She just did her first live stream. She has the live stream bug now. She's going to do all the live streams forever. You should go check her out. She actually knows how to encapsulate cases into short capsule-like discussion points. I know.
Oh, thank you.
It's amazing.
Thank you.
Because it's like the exact opposite of what I do. She has a skill that I don't have. She has the skill to take things and put them into a bite-sized piece. And I'm over here saying, what is a bite-sized piece, Alita? I don't understand. So if you like that kind of thing, that's Alita's angle. Go subscribe to her.
Thank you.
She's doing some wonderful job over there in the YouTubes. Let's get her up to 4,000 subscribers super quick.
Yeah.
If you haven't liked this video already, you should like the video because we tolerated the last 3 minutes of this oral argument for you. So, you get to enjoy our pleasure. So give us a like back. Please subscribe. If you haven't joined the channel already, you can for 99 cents. You can help support us financially. I've been Uncivil Law. My guest has been Alita from Legal Bites. We are out, my friends. Peace and good night.
Good night.